at serial 1, my lord.
You are at serial
Item
one. Start.
My lord, my lord, I have already filed a written notice of submission, my lord, with date chat. My lord, in first page there was some correction, only one line correction. I am supplying the this one, corrected, and I have also supplied the copy to.
What is that one line correction? You have to.
One line correction. It is not BDA. It is BRIT. Initially, it was BRIT.
BDA, BRIT. You know how many pages that was?
Only one page correction.
One page correction.
Yes, is that only the second line and third line, man.
You have filed application.
Pardon.
Have you filed any application?
What?
For amendment?
No, amendment. It's only written notes, my lord.
Written?
It's written notes, not a petition. It's a 2-decade-old petition, my lord. So I don't dare to. My lord, before starting my argument, my lord, I want to take your lordships to 40 years back, my lord. Serial number 1.
You want to take me back?
Here, my lord. Year 1986.
When I was 21 year old. I'm very happy.
Bow down, my lord.
Yeah. My knowledge begins, my lord. In fact, my lord, this was a case of 2006. There's no doubt about that. This scheme was developed by BRIT, Bhubaneswar Regional Incumbent Trust, way back in 1987. Now, also in the meanwhile, 30 years have passed. The area now has become post locality of Bhubaneswar. And a lot of developments have taken place. They say that by that time when the project was developed, there are some leaches that was causing threat to their houses. So they enclosed a portion of the land to protect their houses. Situation has not changed. Also, I didn't get the copy of the writ petition because of dismissal of this the writ petition. Thereafter, my learned friend was kind enough to give me a copy on Friday. The matter related to my lord's night of 2001. My learned friend refers to a judgment of the appellate court requiring that inquiry and all these things. That was also up to 1990. My friend, some other day so that I will call my officer to respect that old file because
this last sentence you could have made the first sentence. I would have given no issue.
Here, my lord, here, Lawrence Senior Counsel is paying for time. I humbly pray for protection, my lord. At least interim order be continued.
What is being done now?
No, my lord, because
interim order.
There was interim order, it was dismissed. Thereafter, I came to picture. I have filed a CMAPL. It was restored without the interim order. That is my predicament, my lord. Let them take time. I may be protected, my lord. That is my humble submission.
lot of time.
3 days, 4 days.
My lord, kindly have a glance. Since this is the third date, I don't have any objection. Only Senior Counsel is praying.
Within 3 days, don't do any.
Plus, we are not going to do because we cannot.
That will be assurance.
My lord, then 22nd. As counsel.
22nd.
Or 17th, whatever, my lord.
22nd, but keep your words.
Well,
Do not trouble.
I'll immediately counting it. So no problem.
Bow down, my lord.
Item 2. Yeah. We'll keep this in our file.
My lord, in item number 2, my lord, I mean VC, my lord. Here is a case, my lord. The petitioner, who is a stevedorer and clearing agent in Paradip Port, has challenged the charge of demurrage to the extent of 5,07,481, Vide Annexure 7 as page 31, my lord. That is under challenge. My lord, your lordship, my lord, as per the agreement and understanding between the President of India and the ENO, the USA government was pleased to send free care food for 11 to all states, and for the state of Odisha for 11 lakhs of poor children and lactating mother. And accordingly, the government of Odisha issued a tender. In that tender, I became successful. Accordingly, agreement was entered into between myself and the government, and so also there was an understanding between the port authority and the government. And for this purpose, my lord, there was no custom charges, no government duty, and port has to give priority of berth and no berth charges and warehouse charges also. Accordingly, my lord.
You are arguing from Delhi?
No, look.
No. If you come here, it will be easy, na? We can exchange our greetings also.
My lord, sorry, my lord, I have undergone a major operation. That's why I am unable to appear, my lord.
Then all right, no issue.
But my lord, thereafter, on 1/4/2098, my lord,
1 second. The impugned order is Annexure 7.
my lord 7,
What
Page- page 31.
What it says?
It says charging of demurrage to the extent of 5,07,481 from the petitioner who is a stevedore or clearing agent, not the owner of the cargo. Cargo owner is the state. Whatever it may be, my lord. Fact remains, my lord. Earlier writ petition was filed. Since they did not allow me to lift the cargo within the stipulated period, then I approached this Hon'Ble Court in WPC number 6881 of 1998, my lord. In spite of repeated direction of this Hon'Ble Court in that writ petition by the division bench, the port authority did not allow me to lift the cargo.
Where is that?
My lord,
Where is that judgment? Which page?
my lord, that has not been annexed, my lord. That for that several orders have been passed, and the writ petition is. I pray the writ petition by 6881 of 98 may be called for, my lord. That is very much necessary. Wherein it is also held by the division bench that if demurrage is chargeable, state will be liable. And in spite of that, they did not allow. Then this Hon'Ble Court directed that the petitioner will engage laborer from outside, and the state administration was directed to give all assistance with the police so that no breach is occasioned. And only thereafter that order was passed on 8/7/98. Only thereafter I was able to lift the cargo. But in the meantime, my lord, for the laches of the port, all the cargo were damaged, and it was used as cattle feed, my lord, the feeds, except the oil. So I pray, my lord, and government has also written after this letter and Annexure 7 to exempt the demurrage, because neither the government nor the petitioner is liable for the same.
You take it so that we can see this. Can sit to my system. You have to lift it, make it little more.
Has been passed in that writ petition.
Yeah.
Writ petition.
Yeah.
May I explain, madam?
Who is liable to
Yes,
pay
I'll just
the
explain.
demurrage?
Here the
Why?
petitioner is a licensee, madam.
You appear for
I am for the Paradip Port Trust.
court.
Yes.
You are one second.
I'm sorry, madam.
Hold back.
Yes.
Hold back. Be slow.
My lord.
Which is the rule which authorizes you to levy the demurrage charge?
Yes. As per Major Port Trust Act,
Show that.
madam, that I have quoted in my counter affidavit, your lordship sees, madam. Before that, may I explain one thing, my lord? Here the entire case is about levy of demurrage charges, my lord. Here 25 lakhs was levied on the petitioner for lifting the cargo. Since it was care cargo, it was meant for child and care, CARE, my lord.
Cargo.
Yes, care cargo. It was bought in from USA with the consent, with the agreement with the President of India and care USA, my lord. That is to be supplied to all women and needy children in India. The petitioner, the original consignee is the state of Odisha. The petitioner was a licensee who was supposed to pick up the cargo from Paradip.
The carrier.
Yes,
That's all.
it. Yes, madam. The consignment is to be delivered to the state of Odisha. Yes, madam. I'm sorry. I'm sorry.
You have to invent full stops, comma, and other.
I'll do that.
In our part.
Yes.
Okay. Now I am asking you.
Yes.
Whose liability it is to pay the demurrage charges?
The person who keeps the consignment in the Paradip port area, in the present case, the petitioner, he is liable.
How petitioner it belongs to whom? To the state.
The cargo is meant for the state government,
Correct.
but the petitioner, being the licensee, had stored the cargo in Paradip Port Trust. A demurrage charges is calculated, which includes the rent, the electricity charges.
Sorry.
What?
Question is very simple.
Yes, madam.
Whose liability it is to pay the demurrage? What the law
The
says?
consignee. Yes,
Consignee.
my lord.
Consignee means who?
My lord, the recipient of the good.
recipient of
The
the
state of Odisha.
recipient of the goods means letter postman brings.
My lord.
Like that, he is another postman.
Yes, my lord.
Letter is sent from USA.
Yes.
It should reach the government.
Yes, my lord.
Postman is the petitioner.
Yes.
Suppose if the letter is not collected by the addressee, can the postman be hanged?
No, here I got your point, my lord. But here what has happened, my lord, the postman has delivered, the letter has been received by the consignee. The goods has been dispatched.
Correct.
They have taken back the goods.
Yeah.
Good has been delivered to the state government.
Yeah.
It is with regard to demurrage charges. What I was coming to, my lord, as per the rules, the Board of Trustees, Paradip Port Trust, have already waived 80% of the demurrage charges.
I am not on that. Who is responsible is the point. You have to
Here, my lord, yes. Yes.
in the responsibility.
Yes, my lord. If your lordship comes to page 23, my lord, that is annexure 3 of the writ petition. Yes.
How did any rule you are referring?
No. This is the letter which says that the petitioner has to get into an agreement with the state of Odisha for delivering that consignment. So that by virtue of that, the petitioner becomes a consignee.
Which is the rule?
My lord, the rule. This is by virtue of an agreement, my lord.
No, you have to show the rule. No? The port trustee is an authority under the Act.
My lord, may I just bring the lordship to page 23, please? Page 23, my lord.
I am seeing that.
Yes.
It's not a
lordship.
rule.
Lordship in the last paragraph.
It is not a rule.
No, it is not a rule, my lord.
Therefore, I am asking you, where are the rules for levying of demurrages?
Yes. Lordship, may kindly see my paragraph, my counter affidavit filed by OP number 2, my lord.
Where is the power to levy?
My lord. Page 48, running page 48, internal page 7. That is
48.
Yes. Para 17 of my counter.
Section 58 of
Yes. My lord. May I place that?
rates
In respect of goods
goods
to be
landed shall be payable immediately on the landing of the goods, and the rates in respect of goods to be removed from the premises of the board, or to be shipped for export, or to be transshipped, shall be payable before the goods are so removed or shipped or non-shipped. But who is absent in the text?
that is section 48 of the MPT Act, Major Port Trust Act.
Right.
Yes, sir. Major Port Trust Act.
What is meant by rates? Rates in respect of goods means what? What is the meaning of the word rate?
Yes, my lord. 48 of MPT Act, my lord, that's
Major Port Trust Act.
my lord.
Such acts, because such cases are very rare, no? You have to
Yes, my lord.
statute.
I understand. Yes, my lord.
What is meant by rate? Take out of the Supreme Court judgment which said what is meant by rate. Major Port Trust Act. Whether the word demurrage will fit into the word rate.
My lord.
What is the law on the point? Get Surendra Malik's words and phrases. The Supreme Court on words and phrases. L.C. Goyal, Supreme Court on phrases. Get those books. Your library does not keep any new books at all. Most of the books I refer are not found in your library. Whether the word rate is defined under the Act?
My lord, I've just verified.
Yes.
Rate includes any toll, due, rent, rate, fee, or charge leviable under this Act.
Leviable under the Act.
48 says that.
Understood. Which section levies it?
Yes, madam.
Section 58.
My lord.
Rates in respect of goods to be landed shall be payable immediately on the landing of the goods, and rates in respect of goods to be removed. Perhaps the case falls into the second part.
My lord, I'll
Goods
clarify.
to be removed.
My lord, 48. 48. A scale of rate for services performed by board.
Meaning? Huh?
May I please, my lord? Section 48.
48. Kindly read.
Yes, my lord. Scales of rates for services performed by board or other person. The authority shall from time to time, by notification in the official gazette, frame a scale of rate at which and a statement of conditions under which any of the services specified hereunder shall be performed by a board or any other person authorized under section 42 or in relation to the port approaches. That is A.
Which are the services?
Yes, madam.
Enlisted services.
Transshipping of passengers or goods between vessels in the port.
Not applicable.
Not applicable.
Yes, next.
D is applicable.
Yes.
Wharfage, storage, or demurrage of goods on any such place.
So you have power to
Yes. that's
levy.
what- Yes, madam.
On whom?
On the consignee, my lord. The recipient. Yes. No, if that the act, my lord, by virtue of the functioning of the authorities, my lord, they become a consignee. Here, my submission is the state of
not defined.
my lord, consignee is defined in the
Read.
yes, yes.
It's a very old act, na?
But it has been over now, my lord, the new act has come.
No, it's all.
Yes.
That word is there even in the old act. I read it when
Yes,
in my
madam.
student days.
Consignee has not been defined, my lord.
I think there is a judgment of Calcutta High Court
My lord,
as to who the consignee is.
I'll verify that.
If that is pinned,
Yes.
then question arises.
May I make one submission?
Yes.
The state government, by virtue of its action, my lord, they have stepped into the shoes of a consignee as because on the request of the state government, 80% of the demurrage charges have been waived.
Waived.
Now the question is about the 20%, whether the state is liable to pay or the petitioner.
What the state says, that is.
State has not filed-
You are after that 20%. Base is irrelevant to you.
Irrelevant to us.
Irrelevant
Yes,
to you.
madam.
But to say that the transporter should give, for that you have to show the law.
My lord, in that case, my lord, we will be happy to receive that amount. Whoever pays by the state government,
No,
or
you have
the-
to print out.
I'll do that. I'll do that. But the state government also has to say because the
No, courts have interpreted this provision. This question is not for the first time it is arising.
it has not been.
With Bali Yatra, it
My
used to carry goods
Yes.
and bring goods
Yes.
from Java, Sumatra, Bali,
Yes.
Thailand, Indonesia, Malaysia, Malaya. So this is not the first time question is arising.
Well,
How courts have treated this section?
I'll verify.
That you have to look into.
Madam.
I'll call this matter at 2.
What should-
Kindly come.
Yes,
Just go to library and
Dr. Ms.
you may.
My learned senior was also.
What is your
My lord, may I prevail, let it come tomorrow or day after tomorrow so that entire orders passed in the earlier writ petition, I can produce my lord.
Yeah, tomorrow. At the request of learned counsel appealing for the petitioner.
That case was for a limited purpose
Yeah.
to seek interference of this honorable court to provide police protection to lift that good.
No, my lord, no. To permit me to lift the cargo and to
Yes.
supply me the port.
He argues one, you argue another, you are not producing the judgment. What the court should?
Sorry, my lord, tomorrow or day after tomorrow I will supply all everything.
Yeah, day after. Reluctantly urgent to day after. At the request of counsel for the petitioner. First up, counsel appealing for the court trustee's request to come with more preparation.
Madam.
Yes.
Grateful.
Mr. Lanka, you have to say, now if 80% is waived at your instance,
Yes.
then you have a stake. Yes.
Item 3. May I please your lordship? This is an application for restoration, my lord. The
Restoration.
yes, my lord.
That was
Restoration
dismissed.
of the contempt proceeding, my lord.
Contempt proceeding.
Proceeding. Yes.
Yes. What is that? What is the order?
Lord, order was passed on 21/19, my lord.
21,
19, my lord.
20 January 19.
Yes, my lord.
What is that
19.
order?
Your lordship may kindly see the contempt proceeding.
It was a judgment.
Yes, my lord. Quoted in the contempt proceeding, page 4, your lordship may kindly see of the contempt petition, my lord. Page 4.
Is for
Yes, my lord. it starts from page 3 and also relevant portion is at page 4, my lord. Direction, my lord.
What is the direction?
Direction, my lord. You will see the petitioner is directed to supply a copy of the writ petition containing all the annexures along with certified copy of this order to the collector Baleswar OP number 3, OP number 1 for convenience and reference to annexure 4 series. No construction work on plot number 167 under Khata number 266 in Mundabuniya shall be taken up till disposal of the aforesaid representation of the petitioner by the collector Baleswar OP number 1, my lord. This was the direction. Interim order was passed in this order, my lord.
Yeah.
My lord,
Did you supply the petition copy in terms of first direction?
yes, my lord.
Where is that?
My lord, your lordship may kindly see the receipt, my lord, your lordship may kindly see annexure.
You sent it by post.
Annexure 1, yes, my lord. And it was produced before the in the office of the collector, my lord. Even if they received the certified copy, my lord, they did not give the receipt, my lord. Therefore, subsequently, the petitioner was compelled to send the
post.
by post, my lord. Annexure 1.
It was sent on
Sent on, my lord.
25/1/2019.
Yes, my lord.
That WP order is dated
Order dated 21/1/19, my lord.
they were not supposed to take any action till your representation was disposed of.
Yes, my
Your
lord.
representation was disposed of when?
My lord, representation was not disposed of during the my lord,
Pendency.
Yes, my lord. Pendency of the representation, my lord. This interim order was passed and no construction work was to be done on the plot in question. But in spite of the order, in spite of the communication of this order of this Hon'Ble Court, the OP number 4 started construction over that plot, my lord.
OP number 4 is who?
My lord, is a contractor, my lord.
Contractor.
My lord, what has happened in this case, my lord? From the residential house of the present petitioner, there is an approach road to the main road. That approach road, village road, my lord, and also it is a government land. On that land, when the building materials were stacked on that plot, my lord, the petitioner complained, why you are stacking the building materials on this plot? How we will come out of our house? They did not hear. Therefore, the present petitioner approached the collector and also the Tahsildar time and again and submitted representation. When that was not taken into consideration, therefore he approached this before this Hon'Ble Court. And this Hon'Ble Court passed the order on 21/1/19 disposing of the writ application, directing the collector to dispose of the representation filed before him, and also as an interim it was directed no construction work was to be done on the plot in question.
Understood.
My lord.
Whether construction was done before disposing of the representation?
Yes, my lord.
When the representation was disposed of?
That
It is still pending.
Still pending, my lord.
What is-
And also, I am coming to another point, my lord. You also may kindly listen. When this contempt proceeding was filed before this Hon'Ble Court, on 19, your lordship may kindly see 13/3/2019 order passed by this Hon'Ble Court. Your lordship may kindly see
13(3) order.
13/3.
13/3/2019 order.
Yes, my lord.
What it says, the further content page of the order, therefore the recipient is not able to submit. Whether that petitioner is residing in the same house now?
Yes, my lord.
She is not coming out for bringing milk, buying.
Yes, my lord. Yes, I am coming. Yes, my lord. I have given a photograph, and this truth of the matter will also speak from that photograph. I will show, my lord, and that has been annexed to the contempt proceeding.
I
My
am
lord.
asking.
Yes, my lord.
For natal place, what you call in your Orissa? Married women will go to their place, na? Their natal family.
My lord.
What you call it? Huh? Sasural. She did not go to Sasural.
Only one person can go in rainy season. even one person cannot go by opening the umbrella, my lord. That is also, your lordship may kindly see in the contempt proceeding, I have annexed the photograph, my lord.
Then what is the other point you want to say?
19, this order was passed, and this honorable court was pleased to hold that this is a serious matter.
Not
The petitioners
13/3/2009.
13.3.
Then
Thereafter, my lord, on 28/3/19, it was again listed, my lord.
what happened that day?
Well, on that day, my lord, the State Council took time that the unauthorized, we are taking steps for removal of the unauthorized construction, my lord.
Now they have removed or not?
They have not, till today, they have not removed.
Why, brother? Keep the orders aside. If you block ingress and egress to a house, it is not a good governance. You tell them to remove. What are the arguable points apart? We are here to do justice.
Nandi, present,
Now,
before your lordship,
today it is there.
CMAPL,
Huh?
for restoration of the earlier contempt petition,
I'll restore it now.
yes, fine.
I'll restore it now.
And once, then your lordship may restore the contempt petition, and I will take instruction and file a reply to that effect. Now, there is a delay in filing this contempt petition.
No, in time.
It's a continuing order, na? Till the representation is disposed of, you should not do it. Continues ad nauseum.
No, delay in filing this restoration.
No, my lord.
How many?
No, there is no
delay.
It is in time.
That I will explain in the.
Within 30 days it has been filed. This contempt proceeding was dismissed on 26/7/24.
Wait, it was dismissed for non-prosecution.
Yes, my lord.
We were not there that day.
Yes, my lord.
Even contempt petitions are dismissed that way.
And
The Contact 227/2019, which alleged violation of orders dated 21/1/2019 and 13/3/2019 was dismissed by the coordinate bench. While order dated
26/7/24.
26/7/2024.
26/6/24.
26/7/24.
26/7/2024. Anyway, which date give that 24 on the ground of non-prosecution. First off, ordinarily, a contempt court cannot dismiss the complaint for non-prosecution because it has to ensure implementation of it. First off, be that as it may. First off, next paragraph. Learned counsel appearing for the petitioner has shown plausible, given explanation for absence on the eventful day. And therefore, the application is entitled to be favored, and accordingly it is. First, the contact number 27 of 2019 is restored to the board. First off, the board, for consideration on merits. First off, next paragraph. Learned government AGA, Mr. Lincoln, is requested to ascertain the ground position in the light of decision whose violation is complained of and come out with a report on the next date of hearing, failing which something bad may happen to his clients. First one, this matter, which date you want, Lenka? That day, you have to ensure that she will have and egress to be Arabs. Simple.
Yes, sir.
You need not depend upon the pleadings and orders at all. We will over common sense and sense of justice. That should govern the litigations. Contempt petition being dismissed for non-prosecution, unheard of in any high court. Yes. But somehow disposing the matter. Yes. I don't know. Which date you want? That day you should do something. I will send some lawyer.
We commencing 27.
27.
Your lordship has restored this.
Yes, yes. I have restored it.
But he has to
Because court committed the mistake in dropping the proceedings. It cannot.
Your Lordship, may paragraph 3 of this petition, paragraph 3 of the petition. He has written that his bail application has been dismissed.
Yes, typographical error.
And dates also, he has to make correction. Law has to be.
Petitioner, with the leave of the court, has corrected certain words in paragraph
3
So in 3
and the date of dismissal of the contempt petition.
with the oral application. Yes, oral application. All right, you rectify that also. Yes, okay. Which the AGA has pointed out. Okay. Yes, next.
Item 4.
Mr. Lenka, I appreciate your application of mind, etc. That's appreciable, really. But you should concentrate more on justice. State should concentrate. There is one famous judgment by Lord Denning as to how the advocates for the state should conduct themselves, which he has mentioned in Landmarks in Law. He has written many books, great books there. Landmarks in Law, Road to Justice. His first book is Road to Justice. Now she wants road to her house. Wonderful books there. Family law, weak law. So many things she has done. Family story. Yeah.
Yes, my lord. Under Annexure 1 and 14 under challenge the writ application, my lord. We are the
one.
Annexure 1 and Annexure 14. We are the explosive dealers, my lord. Here, my lord, one gazette notification by 1/7/2025 of the Union of India. There is a restriction for prohibited for manufacture, import for explosive items, my lord.
Explosive items.
Last to see the page 18, my lord.
Page 18.
18, my lord.
What it says.
Here, my lord. It continues the Ministry of Commerce and Industry Department, Promotion of Industry, Internal Traders, such and such purchase.
Manufacture, possession, and import of electric detonator, explosive of Class 6 and 3 or UN Class 1 Division 1.
Yes.
Is prohibited.
Prohibited.
One second. I'm reading it.
My lord.
With effect from 1 July 2025.
Yes.
Manufacturing is prohibited, possession prohibited, importing is prohibited.
Yes.
But exporting is not. But for exporting also one has to manufacture and possess. So that is also prohibited.
Prohibited.
But this is under which section?
Section, my lord, explosive clause 6, division 3 of even clause 1 of the division 1.
Of the Explosives Act.
Yes. So far our case is concerned, they exempted oil corporation company till next 3 lines, my lord.
Provided that such prohibition, manufacture, possession, and import of permitted delay detonators for usage in coal mines and suitable detonators for oil well logging operations and seismic survey by oil and gas operator companies for oil exploration and production shall not be applicable till 30 September 2025.
I have question of clarity, my lord. We are the dealers. Now we are heavy stock on detonators, my lord. If we are not granted 3 months time, then we will suffer a huge loss. For 3 months time given, we will clear all that explosive materials which are stocked in our godown, my lord. So we are praying for 3 months time. We have granted 3 months to oil corporation company. So far the dealers are concerned, we have not granted any time. Page 49 message. There is a notice to destruction of the detonators. Page 49.
You take notice and
May I submit, my lord? May I submit?
yes, sir. So AST should be the court.
I am just clarifying, my lord. That position I am clarifying. I have received instruction.
High courts. AST should the first court, then he should travel to rest of the courts personally. That is the procedure.
My lord, pass it over, I will come.
Password. Advocate General, Additional Advocate General, ASTs. They are supposed to be in the court hall. Yes.
Item 5. Item 5.
But the petitioner has paid for training on completion of 48 years trained scale of pay under representation at Annexure 6, not yet considered.
What one exercise?
Similar,
Consider that.
Yes.
similar matters have been disposed.
Give that.
They're covered by your lordship.
You have changed the dates and other things.
Yes, ma'am. Only the prayer
The question you have to
re-quoted.
You give a copy to him also. He should know. Yes. Then hold on.
Item 6. This is a matter relating to sanction of pension to block grant employees, Your Lordship. A similar matter, Your Lordship, has passed this header, and this matter is squarely covered by Hemant Kumar Chotra, Your Lordship.
Hemant Kumar Chotra case is pending before the
That is
division.
pending in writ appeal.
Writ appeal is pending.
In a similar matter, Your Lordship has issued notice.
Issue notice, call along with the BP number. Like WhatsApp's notice. Any private party?
Only man, he is there.
No.
Only managing, opposite part number 4 is there, managing committee.
Number 2, P4. Yes.
Item 7. Grateful, Lordship.
May I please, Your Lordship?
Yes.
Punishment imposed in the disciplinary proceeding is under challenge, my lord. The punishment order is at Annexure 13, page 110.
What was the misconduct?
The misconduct that they have said my husband has misappropriated the money. In the meantime, my husband has died. Only I am on the part that only one part of that punishment, I was allowed for compulsory leave. I was allowed for compulsory, though there is no such provision, and it continued till my dismissal.
Compulsorily retired.
Compulsory leave, it continued. It was passed in 2014. Proceeding ended in 2024. And I was dismissed from service. My husband
was dismissed from
service. From 2014 to 2024, that period was treated as no pay.
Yes, because it resulted into dismissal.
My lord, that compulsory leave, because there is no provision for compulsory leave.
No, it's not question of compulsory leave.
Because in other communications, they have said I am under suspension.
Yes.
If I am under that I am saying I am. If my husband would have been under suspension, then he is entitled to substance allowance.
But that was a right of husband. How widow can complain about that?
Only that if that period will be treated, whatever that period will be regularized, whatever period your lordship will decide, only financial benefits she will get. Because dismissal she will not get anything else.
No,
only that
misappropriation happened and therefore dismissed from service.
Yes, my allegation is that misappropriation by 3 employees. Submitted all the documents. My husband has submitted all the documents. I have not misappropriated. In that proceeding, it was established and I was dismissed from service. My husband was dismissed from service. Only the dispute that period, my lord. And no, on my part, there is no law. On my husband's part, there is no lapses that the proceeding continued for years together.
No, that you should have, your husband should have come and said, not now. You have no such.
Yes, I have challenged that. My husband has challenged that. Before my lords, and your lordship disposed of the writ petition, I have given that order, my lord.
Saying that
your lordship directed to supply documents
and complete
the proceeding.
Yes, no, the delay when husband died.
Died on March 1st March 2025.
1st March 25, he had no grievance at all about the delay.
No, my lord.
How can a widow can have?
No, delay, he had challenged, in that proceeding, he had challenged that leave. Because there is no provision for compulsory leave.
The question will not arise because it's a dismissal order.
Yes, my lord.
Dismissal order will date back to the institution of the proceedings only.
No, my lord. only dismissal order will come with effect from the date when it is passed.
Dismissal on
Yes, my lord.
conduct
Because-
involving moral turpitude.
Yes, because it will come into effect from the date when it is passed, not from the date when that proceeding is initiated.
You are right. I stand corrected.
Yes, sorry, my lord.
You take a notice.
My lord, a notice to go, my lord, to the opposite parties.
Issue emergent notice. University and others.
Yes, my lord, all of.
Okay. For UGC appears.
Now, Central Government Council appears.
You take notice.
Yeah, I will take notice to all.
Returnable within 8 weeks. Yes.
Item 8.
Yes.
May I please, my lords?
Yes.
My lords, in this case, the petitioner joined as Swichasevi Shiksha Sahayaka on 13/7/2005, my lord.
To consider for promotion.
My lord.
Others have been granted promotion.
My lord, under Annexure 4, I have given the order of the Director of Elementary Education. The similarly situated persons, they have got the benefit, my lord.
You have not been given.
No, my lord.
You let them consider your representation.
My lord.
Anyway, I am also infected with the same disease now in last 5 months. Good. Right up. Petitioner's prayer column reads as under. Petition prayer column reads as under. First one. That counsel for the petitioner brings to the notice of court petitioner's his client's representation dated 19/6/2025 at Annexure 4.
Annexure 5.
Annexure 5.
Annexure 5, my lord. Reference.
Wherein a request is made for according promotion to the next level, as has been done in the case of other similarly circumstanced persons. First up, kindly be seated. Basanto.
My lord, under Annexure 4.
Sit down, sit down. Sit
My
down.
lord.
Learned counsel for the petitioner submits that when the promotion to the post of level 4 with effect from 2/8/2015 and level 3 with effect from 2/8/2017 have to be granted, there is no reason for keeping the representation in a limbo. First off, he quotes Article 350 of the Constitution of India, as has been extensively construed by various high courts in the country. First off, next paragraph. Mr. Lenka,
Yes, sir.
what do you say? Do you agree to consider or?
No, no.
Learned AGA, Mr. Lenka, in his usual fairness, agrees with the suggestion of this court that the subject representation needs to meet its fate at the hands of district education officer.
The director.
At the hands of second OP number 2, namely Director Elementary Education, within a reasonable time. First off, however, he puts a caveat that the time period be prescribed and grounds be kept open for consideration. First off, with this proposal, counsel for the petitioner is also agreeable. Next one, in the above circumstances, petition is disposed of 8 weeks. Sorry, sick, no course. Next. Item 9. Yeah, 9.
In the year 2015, the petitioner executed a work, my lord. And for that work, 10,000 rupees in shape of national saving certificates was furnished as security. And that work was completed in the 2015 and the NSC were released, but no intimation was issued by the notified area council to the post office regarding release of the.
Therefore, they are not releasing the amount.
Yes.
Any representation you have given?
Yes, I have given the representation and
Is over and you have returned the NSC, but you have not sent the intimation to the post office.
That is a,
No.
your lordship, that is NSC document. to separate, they have independent opinion.
No, question is not that. Under the contract, the tender law, which Singhania writes, where you have taken a security deposit for ensuring maintenance of road, well, etc., for a particular period, safety period. After that, you cannot retain that money unless there is damage done. No, you have returned the NSCs and you have not informed the post office. You honor those NSCs. You consider that representation.
NSC to act, not the state government. NSC, that's the law.
Who is the advocate for that? Issue emergent notice, returnable within 2 weeks. AGA for?
One.
Yeah.
Or your Lakshmi can.
NSC is coming under the state.
No, who has to say? Why? But you have not. You have made all postmaster to postman to everybody. You have made a party.
Post office has no role to play because if they are not communicated, then we have nothing.
From the national
State government has to intimate.
state government.
No, state has no role. Because the
What
contract,
AST says is, unless the state clears saying that honor those certificates.
OP 2 and 3.
That executive
OP 2 and 3 to
notified area council Daspala. He is to implement.
Appears for notified area council.
3.
Walla.
OP number 3 is to represent.
Executive officer notified area.
They don't have a channel lawyer.
Issue emergent notice. Now, Mr. Lenka accepts notice for 1. Learned ESG accepts notice for 4. Emergent notice to 2 and 3. Returnable within 2 weeks. Okay. Item 10.
Regularization of a class for employee has been rejected. He has approached my lords earlier. The lordship are directed to consider his representation. His representation has been rejected.
Rejected on what ground?
On the ground that there is no post. Lordship is annexed 5 page
How many
20.
years?
10 years.
10 years.
My lord.
But that particular GO was there now, which said
6 years.
6 years.
Yes,
After
yes.
6 years, Mr. Lenka accepts notice for the OP.
Yes.
All private, no private party.
No private.
Ah,
The notice to go, my lord.
the four. OP 4. Yes.
Item 11.
My lord, this is a claim of proper calculation of UGC scale of pay as that of the demonstrator of Utkal University and non-government colleges, my lord. And representation is pending as per NHF 4 and identical cases issue notice, my lord.
Issue emergent notice. AG appears for them. Commissioner. See that Commissioner from Secretary Department AGA for 1 and 2. Emergent notice to 3. Yes. Next. Item 12.
My lord, 11 item number, second item is also same, my lord.
Huh?
In item-
The white is same. Okay.
Item 12.
Ah.
The petitioner is working as programmer cum accountant under opposite party number 4, who is district education officer comes district nodal officer.
What is your representation at Annexure 6?
Representation with regard to regulation, my lord. That is pending before OP number 4. And the petitioner has rendered more than 13 years of service.
Petitioner, who claims to have put in about 13 years of spotless service, has made a representation dated 5/4/2025 at Annexure 6, wherein he has sought for regularization of service. First up, Learned Counsel for the petitioner submits that the representation of the kind cannot be kept pending ad infinitum with no justification whatsoever in the light of Article 350 of the Constitution of India. Mr. G, what do you say? Do you consider?
Yes, yes.
Learned AGA Mr. G, appearing for the OPs, graciously agrees with the suggestion of this court that a subject representation should meet its fate at the hands of
OP number 4, your lordship.
OP number 4, District Education Officer, within a reasonable time. First up, he caveats that reasonable time be prescribed and all grounds be kept open with which counsel appearing for the petitioner bottles. First up. Next up, 8 weeks open to solicit.
So the date of the representation is 3/4/2025.
No, but 3/4, but
Yes, Lordship.
on the head for it, 5/4/25.
No, 3/4/2025.
3/4/20. Okay,
Great for me.
next. Item 13. Yeah, 30. Yes,
In a similar matter, notice has already been issued.
Notice has been issued. What is that matter about, brother?
This Lordship, this matter is about challenging 4(1) of rule.
Placement rule.
Placement rules.
This rule.
So 9 years of extra service is to be rendered.
Emergent notice, as in that, all along with. All these matters. All the three matters. Any private party?
No, the secretary of the governing body of
Governing body. Okay. Others, Mr. G. Yes, next. Item 14.
So petition is a block grant teacher has prayed for pensionary benefits as per Hemant Kumar Chatra. So this is notice.
Notice जायचे अगोदर. Notice was issued earlier.
Earlier notice was issued.
Notice will maybe issued in these cases.
But 88. To emergent notice, 88 accept notice for. Any institution is also party?
No,
No private party.
managing committee.
Managing committee is there, no?
Yes, managing.
Yes, emergent notice to 4. Returnable within 4 weeks. Next. Item 15.
In this same similar pension matter, notice to go to the opposite panel for.
There is connected matter. Some other matters were also.
Some other-
You get some. Call this matter along with WP number. Item 15. Similar matters.
Item 15 is the similar nature matter.
Which one with 14?
The pension.
This is also no Hemant Chatra, my lord.
15 also. 14, 15 together.
6 item. 6 item there is here.
Item 16.
May I please your lordship? The petitioner has filed this writ application seeking a
Make use
direction.
of mic.
Seeking a direction
Grab
for
that mic near you. Yes.
seeking a direction for the regulation as well as the consequential service benefit along at par with one Dhyan Ranjan Das. The lordship may kindly see Annexure 2. The petitioner and one Dhyan Ranjan Das was
Any representation you had given?
under Annexure 6 that was pending before the collector.
Collector.
My lord.
Antedating of your date of regularization. You consider that representation. Short grievance of the petitioner E as to non-consideration of the representation at Annexure 6 series, wherein he has sought for antedating of regularization and to accord promotion to the post of head saver at par with similarly situated persons. Like Han Ranjan Das. First off, counsel for the petitioner submits that if a direction is issued for consideration of the subject representation, his client will be satisfied. First off. Next paragraph. Learned AGM Mr. G is agreeable with the proposal of the petitioner, provided that a reasonable time is prescribed for consideration of the representation and all contentions of the parties are kept open. First off. This is appreciable. Next paragraph. 8 weeks, solicit, no costs.
Sub item is also same.
Yes. Item 17. Engagement order to be issued.
My lord.
So the post of teacher TGT.
TGT.
Any representation you have made?
Annexure 5 is the representation and Annexure 7 was the direction for re-engagement, which is not implemented.
There, Annexure 7.
7.
Why, Mr. G, that is not?
My lord, sir, here. This is pending for taking over by the government. And in the meantime, it was earlier with opposite party number 5.
When it was? That was long ago.
No, my lord.
But taking over happened when?
The process is on, my lord.
But how it comes in the way of this?
19/6/2025, Annexure 7. The lordship kindly see.
Correct, I understand. But question is how that process will come in the way. Who should pilot the ship is question. But who should be the passengers? Whoever the passengers. Your case is pilot is being changed.
My lord.
Let him change. But where is the problem?
My lords, in the meantime, they are also getting their money, salary they are getting. Only the final decision is to be taken.
Final decision has to
be taken, my lord.
My lord,
renewal of contract.
There is letter, but we are not given the letter to continue also.
That is that renewal of contract is not given.
Exactly.
You let them consider your 19625, your representation. You make a representation in the light of 19625 order.
Yes.
Mr. Behura, let them make a representation. Petition prayer is scripted as that. First, counsel for the petitioner draws attention of court to the order dated 8/9/2000 letter
19/6. 19/6/2020.
Client's letter dated 19/6/2025. Not client's letter. Additional secretary to government it is.
My lord.
Additional secretary to government's letter dated
19/6/2025,
which supports prayer of the petitioner. First up, learned DG appearing for the OPs on request very fairly agrees that he would instruct OP number.
My lords, in fact, this is addressed to General Manager Orissa Hydropower Corporation. They are very different. We don't represent.
Submit that if an appropriate representation is given to his officials, there would be no difficulty for considering the same in a time-bound manner if all contentions are kept open. First off, with this proposal, with counsel for the petitioner is agreeable. Next part, in the above circumstances, petition is disposed of, reserving liberty to the petitioner to make a fresh representation to the jurisdictional OPs. And if one is made within 2 weeks, the same shall be considered by the jurisdictional OPs within an outer limit of 8 weeks. First, all contentions of law and facts are kept open to solicit. No cost. Next. Item 18. You have to make representation within 2 weeks.
Item 18 is regularization matter. From the date of initial appointment, his junior has been regularized since from the date of appointment. And similar
representation is 22/11/20. Petitioner has made a representation dated 22/11/24, a copy whereof avails at Annexure 6 series, wherein a request is made to regularize his services with effect from the date of entry into service, namely 5/1/1984, which benefit, according to counsel for the petitioner, has been accorded to other similarly circumstanced employees. First off, he tells that the representation has been kept eternally pending, and this goes contrary to Article 350 mandate of the Constitution. First off, learned AGM.
My lords, this is pertaining to Utkal University, my lords.
University.
My lords.
You appear for
1 and 2, but 3 and 4 are the
appearing for OP numbers 1 and 2 submits that the decision has to be taken by the university concerned, namely OP numbers 3 and 4. First off, you give representation to OP number 3 and 4.
I have given.
You have given. Where is that shown?
That is
the 6 series. Counsel for the petitioner replies that such a representation has been given in series wide Annexure 6, and they too have remained unconsidered at the hands of OP numbers 3 and 4. First off, he submits that unless a direction is issued, consideration may not happen. Next paragraph. Having heard learned counsel for the petitioner and learned AGA alone, no notice having been sent to OP numbers 3 and 4, comma, this court is of the considered opinion that OP numbers 3 and 4 should not keep representations of the kind in limbo indefinitely. First term. Therefore, they are directed to consider or cause to be considered the subject representations in accordance with law after receiving necessary information from the petitioner if required within a reasonable time and preferably within a period of 8 weeks. First off, all contentions of law and facts are kept open. Next paragraph. In the above circumstances and with the above observations, petition is disposed of. First off, registry to send a copy of this order to OP numbers 3 and 4 by speed post immediately. First off, below, note, NOT. No notice is sent to 3 and 4 since no the prayer is innocuous and order made is also. Okay.
Item 19. Item 19.
My lord.
Yes.
This case, my lord, petitioner challenging the rejection order under Annexure 7, my lord, not promoted the petitioner with effect from the 2014, my lord. Client glance Annexure 7, my lord.
2014. Earlier petition was also there. 8501 was your petition.
My lord.
You take notice, Mr.
My lord.
Behur?
My lord.
Mr. Behur, the DG is requested to accept notice for all OPs. Okay. Call after 8 weeks. In the meanwhile, the counter may be filed. Okay.
Item 20.
Yes, sir.
The petitioner filed this case challenging the order of confiscation of 26/11/2024 passed by the authorized.
My lords, this is Excise Act. I think this is not assigned to my lords. This is
matter.
My lord, the excise superintendent have seized.
Correct. It does not come to my court. Though I like excise, it does not come here. I like both excise and exercise. Let it go to other court.
Other bench, my lord.
Push this matter before the roster court after examining after verifying the factuals. Okay. Next.
Item 21.
May I please ask? But the petitioner's high school was established in the year 1998.
Certiorari, let the notice go.
Yes, notice.
Right. They're not prejudice. This is competition of school, my lord.
No, not competition. But this is contrary to the rules. But our high school has been functioning since 1998, and the school has also been enlisted for granting aid as per the granting aid order of 2013, but formal notification has not yet been issued. Your Lordship may kindly turn to Annexure 4 at page 20. This is the communication made by the district education officer where our school is eligible to receive granting aid, serial number 1. In the, my lord, that is in the village Gocha. Now in the same village, my lord, one upper primary school, a government upper primary school was there. The government has taken a decision to upgrade that school to a high school. Your Lordship may kindly turn to Annexure 7 at page 30, which is also in the same village. Annexure 7.
Upgraded, what happens?
My lord, if it is upgraded, certainly rules length of our school will fall down and it will face closure and it will be derecognized because that is the feeder school of our school. That is a upper primary school. Now that school has been upgraded to a high school and both the schools are located in the same village. And Your Lordship, for a moment, Your Lordship may kindly see Rule 3 of the 1991 rules, that statutory provision. But where there is already a high school, either private or government, no second school is required. Your Lordship may kindly see.
You take notice then?
Well,
then I was about to dismiss this petition on the ground of Gloucester Grammar.
Yes, but I'm conscious of that, and another is the mayor of
policy decision.
Yes.
This is policy decision.
This is contrary to the rules.
Rule says.
You
cannot establish.
No, my lord. There is no rule.
You also may kindly see Rule 3. Just I am placing.
You copy to him.
No, that is in the manual.
No, the scheme was to refer to
Yes,
the
we will file counter.
emergent notice returnable within 6 weeks.
But
The AG accepts notice for the person. An application seeking infant protection is moved supported by affidavit. First stop. Learned senior advocate Mr. Swain submits that if the impugned decision is implemented, that may strike the death knell of the other school, and therefore that needs to be interdicted. First stop. A prima facie case is made out for granting interim protection. First stop. In the above circumstances, the application is disposed of, directing the parties to maintain status quo as to the upgradation till next date of hearing.
Yes. In terms of Annexure 7.
In terms of Annexure 7. Okay. If there is a rule you are protecting, because rule provides an exception.
Otherwise, consensus your lordship decision in Karnataka. I have also got that decision.
I have given that.
Yes.
That is under Excise Act. Correct?
Yes, that is Excise Act.
They wanted to correct shop.
You also referred those two decisions.
Yes. Okay.
Lordship dismiss that petition.
Dismiss that. Yes. Okay. Just keep it in that file. Something. Yes.
Item 22.
My lord, case relates to regularization of class for employee of Orissa University of Agriculture and Technology. Identical matter, your lordship has issued notice.
Regularization.
My lord, of class for employee of Orissa University of Agriculture and Technology.
Yes, issue emergent notice. A state is not a party.
My lord, I have ordered
state is also. My lord. Mr. Mohan accepts PGA.
2-3 notice to issue. 2-3.
2 and one number 1, Mohan 2 and 3 emergent notice. Call along.
Item 23.
Maybe.
Yes, sir.
Pursuant to the order Annexure 8, Annexure 8, the gradation list, objection was invited and the petition also filed an objection. That is Annexure 9 and only page 35.
For promotion.
For promotion.
Promotion to head saver.
Head saver, lordship.
If this is considered, you will be happy.
Lordship.
But short grievance of the petitioner is as to non-consideration of his representation dated 14/7/2025, wherein the last paragraph reads as under Annexure 9. First off, learned counsel for the petitioner submits that his client is having having all requisites, including seniority and qualifications, and therefore he is entitled to be promoted as a head saver in terms of the representation. First off, he also adds that such representations will not meet their fate unless the writ court intervenes. Next paragraph. Mr. Mohanty, you consider the representations. Learned AG Mr. Mohanty, in all fairness, submits that he would instruct OP number.
OP number is collectors.
3.
OP number 3, lordship.
Jurisdictional OPs to look into the grievance of the petitioner as has been aired in the subject representation in accordance with law, if a reasonable period is prescribed and all contentions are kept over. First up, this is absolutely fair. Next part, in the above circumstances, 8 weeks, usual terms. Okay. Next.
Lordship, I must have one thing. Lordship, till then, no. Final lesson will taken pursuant to the annexed date. Till disposal of the representation, the collector may not take the final decision pursuant to the gradation list by the annexed date.
No, if it happens, you will be entitled to do that. No?
The same
sentence you can see. The gradation list, if finalized, will be subject to the result of representation. That will go. Okay.
Item 24.
Well, here the petitioner challenged the disciplinary proceeding on 2 accounts. First is that on basis of a complaint, criminal case has been initiated against the petitioner
for beating the student. And this honorable court was that criminal proceeding. Kindly have a glance to Annexure 9. By after getting the inquiry report and the statement of the informant, court come to the finding there is no case against the petitioner, and that has been quashed. And the second ground of challenge, that the proceeding charge memo has been issued by the incompetent authority.
He is not competent to take action. Who is the competent authority?
Competent is the district education officer.
DO.
Yes.
Under which rule?
Yes. Their own circular.
Circular?
Yes.
Power is given by the circular?
Yes. Kindly have a glance to the page 3 of that circular. Okay.
Page 3?
Page 3.
Paragraph?
That name, first para.
The district election officer will be the appointing authority and general controlling authority of the institution of teaching and non-teaching secondary and secondary school. Except the cadre which belongs to state cadre. The cadre of the elementary teacher. Is elementary teacher?
The assistant teacher. Elementary.
Assistant teacher.
Elementary and in the high school. And the next, the district education will be the discipline authority
in the authority.
Yes.
You take the notice, Mr. Monty is requesting in this. All. First, an application is moved, supported by an affidavit. An application in number so supported by affidavit is moved to stall the ongoing disciplinary proceedings. First, learned counsel for the petitioner draws attention of the court to the quashment of criminal proceedings in respect of the very same event by the coordinate bench of this court in what is that, criminal petition or what?
Yes, criminal petition. CRLMC 1498 of 2025.
Right down.
It is annexure 9. I have made annexure.
Yeah. Criminal petition. White order dated?
Order dated 15/5/2025.
15/5/2025. First off. He also points out that in terms of circular number 15602, dated 6/7/2013. Brother, actually, this is a matter to be allowed. Where is the power? This circular itself says the disciplinary power is with the concerned authority, not with this person.
On the basis of that circular?
Yes, you take appropriate action if the competent authority.
Right. That order may be passed and disposed.
Counsel for the petitioner is before this court for calling in question the subject disciplinary proceedings on two grounds. One, the authority who instituted the disciplinary proceedings is incompetent in terms of the government circular number 15602, dated 6/7/2013, page 3, para 2. And the criminal proceedings that were structured on the very same fact matrix have been quashed. Why the annexure 9? Annexure 9. First off, counsel also submits that when a proceeding is constituted by an incompetent authority, in the eye of law, or not yes.
This is the Supreme Court judgment.
In support of that, he presses into service a decision of the apex court in Next, learned AGA appearing for the OPs who opposes the petition, contending that all contentions can be taken up by the petitioner before the competent authority, and therefore writ petition is misconceived. First, having heard learned counsel for the parties and having perused the petition papers, this court is of the considered opinion that the subject proceedings are incompetent in as much as, in terms of the circular in question, the power of disciplinary proceedings are granted to the district education officer. And not to the one who has initiated the proceeding. First off, the said paragraph reads as under. You read me, produce this. Next paragraph. The above being said, Learned AG is right in telling that it is for the competent authority to take a decision whether the criminal, what happened on the criminal side should interdict the proceedings or not, disciplinary proceedings or not. First of all, there is force in this submission. Next part, in the above circumstances, petition is allowed in part. Semicolon. Impugned order dated, the writ of certiorari issued. Impugned order
13/5/2025.
13/5 order dated 921 dated 13/5/2025 at annexure 4 series. 4 series. First off, thus the petitioner is for the time being relieved of the disciplinary proceedings in question. First off, however, liberty is reserved to the competent authority to take the decision afresh, if warranted. First off, in that connection, all contentious are kept out. No comes. I will revert within few minutes.
That is also Supreme Court says this manner. As your lordship said, they can do that.
They have to do that. No? Okay. Even Ramlal says that.
Yes.
Primary school, government primary school, that was established in the year 1918. But an order was passed way back in the year 2020 to merge that school with another school, that is Bholidas Primary, Central Bholidas Primary School. That merger order was challenged before this Honorable Court by filing a writ petition, that is WPC number 29269 of 2022.
Take notice. This matter has to be heard.
Yes.
Issue emergent notice.
Your Lordship may fix a short written note.
Accepts notice for the OPs. Yeah, cluster resource also.
Yes. Cluster for government, my Lord, friend.
Emergent notice returnable within 8 weeks, 6 weeks. Yes. So.
Item 26.
Lord, the petitioner is retired and also retired since 31/3/22 and also operating the fourth stage of his cancer. Is returned back from Tata Memorial, yet to get pension and all these things, only because of a proceeding. But that proceeding is not held to be illegal by the court judgment of another case, wherein they say that if a retired employee of an aided institution employee is not to be proceeded against, because there is no rule for that purpose. I have given that judgment at Annexure 3 of the coordinate bench. I have annexed it. Sorry, my lord, that is.
No, if they are initiated before retirement, they can be.
No, that is after retirement.
After retirement.
After it, kindly see, my lord. Annexure 3, the date is the proceeding. It is on 6/5/22. I retired on 31/3/22.
6/5/22. 31/3 you retired.
22. So that is not one. That is the judgment I have annexed and Annexure 5. And my lord, this kindly see his plight. He is in the last stage. He is unable to talk even. That is the. He came before this honorable court. This honorable court directed for consideration, representation in light of all these things, but nothing has been done. Instead of filing, if you will go for a contempt analysis, you will not get anything. You will leave the world. Only take consideration of these facts, my brother. He is yet to get all this retirement benefit, which is very much required for his treatment. Even whatever the necessary treatment.
Sir, my lord, one thing, my lord. I am conscious about that coordinate judgment in other case. That is also in our Odisha case, that is Bhagirath Jana versus Odisha State Fund. But here the petitioner retired in the month of March 31st,
correct,
2022. But the initiation proceeding was prior to that, that is 14 to 2022.
No. Kindly see Annexure 3. That is the charge memo. It is
the proceedings are initiated when the charge memo
is filed. So it is after.
But remember page 18, my lord.
This is complicated.
The memorandum and article of charge.
No, it's been issued. Article of charge has been issued now.
Issued on 6/22. Kindly see the head note. Page 17.
2/2022.
My lord, kindly
The
see.
next page.
Kindly see, madam. Page 17. The
Page
forwarding.
17.
Yes. I am to send herewith the draft charge memorandum dated so and so, framed against the delinquent Kumares Ratha, ex-reader so and so, retired, in triplicate, and request you to serve the same on Ratha, return on.
But come to the next page.
Yes, that he is saying here only. He says a charge memo might have been framed by him on 14/2, but this has been only served on me on 6/5/22. It has been in the preface he has stated so. And moreover, this judgment may kindly be seen. Even the Honorable Court has gone to the extent, even if it is instituted prior to retirement, this is also not permissible to continue further. Kindly see the judgment of this Honorable Court.
In the absence of enabling provisions.
Yes, under the rule.
You look into it too.
No, but that was can you see the sufferings? That is why he was before this Honorable Court. This Honorable Court directed for consideration of the representation. But till date, that was, I have quoted my Lord's order.
No, I will issue notice now. Mr. Das.
He is to get, yes.
Will issue emergent notice and stay the ongoing proceedings.
Even if I only get the money, my lord, proceeding, they're not proceeding. The man is unable to move now. He's in the deathbed.
No, will stay the proceeding.
Only he is to get some benefit.
How can that?
Only they will issue emergent
notice. By staying the process, no way he will be. A short date will be fixed.
Yes.
By that, the proceeding, communication, and prior to or it is post-retirement. It will be clarified.
Correct.
So it will be easier.
Any sort of issue emergent notice. Mr. Mohanty accepts notice for 1, 2, 3. Emergent notice to 4, returnable within 3 weeks.
Okay. Can it be earlier? I will take notice by special thing because here's the condition I know, my lord.
In addition to taking ritual steps, petitioner is permitted to take hand summons to copy number 4. Copy number 4.
Fix a date.
I said returnable within 3 weeks.
No, that it will not be listed. That I am paying for this particular case. I am not paying other cases. You see the
if it is not posted, no memo. I remember.
Memo is all right, my lord. Kindly, if you
now I have made today I have issued a general direction saying that wherever matters are filed within 1 week, maximum 10 days, all they should be posted. Now I have fixed within 3 weeks. Means after service, post immediately after service.
Okay. Can it be 2 weeks? I know the person, his wife is suffering. Yes, regularly disturbing.
For that, I suggested, my lord, from this side as well.
Yes, my
petitioner should not suffer.
Correct.
So let it be 3 weeks. Let them take the notice. By that, at the earliest, we can take.
Law has been settled by this court. I think more to be decided.
Yes. 2 weeks.
Fine.
Item 27.
Well, in the second round of litigation, Annexure 10 is the impinging order, and pursuant to Annexure 8, the earlier order, they have rejected my case without assigning any valid reason. The 68 is the operative portion of the rejection order. You also directed to consider the my case in taking into account to judgment of the court. Now they have rejected, saying that the judgment is related to school. Your petitioner is an employee of college, therefore that judgment is not applicable. But the rule is meant for both college and school.
College and the
school. That's
the only reason.
That is the only reason they are saying.
Where is that reasoning?
Page 68, my lord. The second paragraph. In the present case, the petitioner is either
relied upon is applicable only to the college and not to the school.
Not to the school. They have stated
career progression.
Yes. That revised scale 1/1/16 to 30th September 2017. That period has not been extended, even though all government employees already got the benefit from 1/1/2016.
Take notice. The accepts notice for all this. Yes.
All connected matters same.
Yes, same. Each other.
Many pleaders. In this case, the present petitioner has been allegedly take the multiple allotment of assets from Bhubaneswar Development Authority, but in fact it is not a multiple allotment. The petitioner has taken only one plot. Basing upon the mistake of fact, the Vigilance Authority has seized the document, as a result of which the petitioner was not able to avail the post allotment services. kindly see, my lord, the annexure 16, page number 37, paragraph number, second paragraph, my lord. But as the multiple assets are not clearly mentioned against Sri Das, the Vigilance Department has not seized the case record. At that time, on inquiry by the OST Task Force BDA, it is found that only one asset bearing plot number 171 under Prachi.
Emergent notice.
I am only for one, opposite one man.
The ASC appears for one, emergent notice to the rest. First, an application supported by affidavit in number so and so is moved. Any application is moved?
No, my lord. No, I is.
Others. Emergent notice, returnable within 8 weeks.
Item 29.
And the petitioner has filed an application before the Tahsildar cutoff to obtain the legal heirs details of the loanee who has died, and thereafter, in spite of several letters, he has not deposited the amount. The case is pending for recovery of the loan before the DRAT Kolkata, my lord. And due to non-availability of legal heir details, the bank is unable to give the same before the DRAT Kolkata. For that reason, previously approached the Hon'Ble Court, and the Hon'Ble Court directed to file an application.
Heirship certificate. The legal heir
certificate of details only. If there is a details they will give, then the bank will make them party, and the proceeding will be proceeded at DRAT Kolkata, my lord.
What should be done now?
Only if my learned friend will take instruction so that it can be only legal heir detail. If they will supply, then it can be sufficed the case of the bank to.
You for supply the details of the case pending. That legal heirship certificate case. What are the particulars you need?
The legal heirs of the person who is a loanee, my lord.
Legal representative.
The representative only.
You have to furnish legal representative. Public money it is.
I have already applied.
Oh, well, this is an online application, my lord. The result is also communicated through online, my lord.
No.
They have to see the.
No, it has not been come.
Yes, my lord. That is my instruction, my lord. Morning
communicated.
Yes. No, communicated.
We have not communicated. Only for that reason I am saying that my lord will take instruction. What they have communicated.
They have not supplied the required documents, my lord.
No, whatever documents you need, you can tell him. These are the documents, yes, sir, you have to supply. Then they will supply. Yes. Thereafter, decision will be taken. You have not supplied, and therefore I will sleep over the matter. There is no doubt.
There is a portal. They have applied in online. They have not applied through hard copy, my lord. They have applied through online. We are also uploaded in the online, my lord. I have morning in the morning, my lord. I have
verified.
Verify it and give it.
That I am submitting before my lord.
You at least give a small statement.
Yes, my lord. Yes, that's what I have taken out tomorrow. I will.
Who accepts notice or request for OPs agrees to come out with a short statement. First off, call this matter week after next.
Yes, ma'am.
Since it lies in a narrow compass.
Item 30.
Item 30, actually law has been let down. Yes, that my lord have also decided the writ appeal in this my lord's order. In the writ appeal, confirming that order. No.
So your representation to be considered in the light of that is judgment, my lord.
Yes.
Justice Satpathi's judgment.
Judgment, my lord, have also by relying upon other Supreme Court judgment and another coordinate bench judgment of the Honorable Chief Justice, pass the writ appeal. Confirm that order. In my lord's order, all these orders have been quoted. Division.
Is it covered by the judgment? Mr. ASC, what do you say? You want to look into and come back? And again, consideration of the representation in the light of these two judgments. That's all. Kindly be seated. Petitioner has made a representation to the Director, Department of Higher Secondary Education, at the next 4, wherein he has requested for the release of arrears of salary for the period between 1/6/1994 and 18/7/2010 in the light of certain decisions of this court. First one, learned counsel for the petitioner submits that a learned single judge of this, a coordinate bench of this court in WPC number 15658 of 2020, etc., disposed of on 21/4/2023, has accorded benefit to employees of the kind, and that the said order has been affirmed by a division bench in writ appeal number 1350 of 2024, disposed of on which date? 17/7/2025. Well, first one. He submits that if the subject representation is considered in the light of the said decisions, in a time-bound way, his claim could be satisfactory. First, learned ASC appearing for the OPs fairly agrees with the suggestion of this court that OP number 2 would look into the grievance of the petitioner as has been aired in the subject representation, keeping in view the law, rules, circulars, and the decision cited at the bar. If a reasonable time is granted, prescribed, and all contentions of the parties are kept open. First off, with this proposal, counsel for the petitioner is agreeable. Next part. In the above circumstances, this put of 8 weeks open to solicit. No parts. Okay. We'll leave it quickly, right? In the filings and put. Next.
Item 31.
Yes.
Yes. Lord, the present petitioner approached this honorable court for seeking a direction to opposite party number 2, Secretary Odisha State Housing Board, for grant of permission to transfer the ownership of land in favor of the opposite party number 4. Accordingly, the present petitioner on 24/6/2025 filed an application before the opposite party by annexure 4, along with the transfer fee amounting to rupees 15 lakhs summer, and that was
no decision is taken on that.
Thereafter, they have called me by annexure 5 on 22nd September 2005 to come physically appearance and a verification of document. Thereafter, no fruitful action has been taken. Thereafter, according to annexure 6, I have filed a representation to consider my application and grant permission. Opposite party number 2.
2 is not state.
Not state. Odisha State Housing Board.
Housing Board.
Opposite party number 2, Secretary.
Who appears for Housing Board? Any standing counsel is there?
Only direction may be given. Consider. Annexure 6. Within a stipulated period. That's why the petition is a old ailing person, he cannot vote for. Then authority will be considered.
The short grievance of the petitioner is as to non-consideration of his representation dated 26 September 2023, a copy whereof avails at Annexure 6, wherein he has sought for, she has sought for permission to alienate the property.
Petitioner is Dr. Nurul Amin.
operating. First one. Learned counsel for the petitioner also tells the court that whatever fee is prescribed has already been remitted to OP number 2. Yes. And despite that, no final decision has been taken in the matter. First one. Learned AAC appearing for OP number 2. OP number 1. 1 and 2. 1 and 2, both, na?
Only one, government. Yes, but that secretary housing board.
Housing.
It's a state housing board.
OP number 1 points out that essentially the matter lies in the domain of OP numbers 2, 3 and 4, 2 and 3. 2 and 3. 2 and 3. And therefore, his client is helpless. First off, there is force in this submission. At this stage, counsel for the petitioner submits that since the prayer is innocuous, no notice be issued to any of the respondents, and what would suffice would be a direction to an order to pass order on the subject representation in accordance with law. First off, with this, court is agreeable. Next paragraph. In the above circumstances, 8 weeks, open to solicit, then it hardly needs to be stated that OP number 5, 2, no. OP number 5 to be heard in the matter, na?
OP number 4 is the private party
it hardly needs to be stated that OP number 4. You appear for OP number 4. You appear for OP number 4. OP number 4 to be heard before taking a decision on the subject representation. Mention of Madam's name. What's your name?
Shweta Rautre.
Okay. All contributions kept. Registry to send a copy of this order by speed post to OP numbers 2 and 3 immediately. Okay.
My lord, the date of the representative 26 September 2025 in place of 23.
25.
My lord.
26 September 20.
Within 4 weeks, my lord. 8 weeks.
Within 8 weeks. 8 weeks. 8 weeks. Yes.
Item 32.
Yes, sir.
It is that matter, my lord. The letter dated 30th August 2005, it has already vexed your lordship that the opposite party insisting for Oriya language as second language, while I have been prosecuting for last Sanskrit and Hindi. In that case, my lord, your lordship, that matter is item number 62. And now, my lord, the registration is going on. The last date is today, my lord. They are insisting, last date is today. They are insisting to register Oriya language. Therefore, my lord, lordship may protect, but your lordship has crystal clearly said that the outcome of the 62, then in that case, will subject.
Now admission is granted to you.
No, my lord. That I have approached before lordship for registration. They are insisting to register in Oriya language.
You want to study in which language?
Sanskrit and Hindi. Two petitioner. Because
how can you compel a person to study language?
No.
Because 8th schedule, which is that 8th schedule? How many languages are enlisted in the constitution? Sanskrit is also there, no? Think of. Go to 8th schedule. Give it to the council. Let them do that. Show that which are the languages scheduled in the listed in the 8th schedule to the constitution.
No, that is there, but I am not disputing. But this is lordship kindly have to page 46 of the petition, my lord.
Yes.
Now that will come. What are the languages, brother?
Assamese, Bengalis, Bodo, Dogri.
Read where is Sanskrit?
Sanskrit is in 17.
Is this
17?
17.
Then
yes, brother.
Then Hindi is not in 6th. So we are prosecuting Hindi and Sanskrit. And as per the guideline of the CBSE. But in the mid-section, session, my lord, the opposite party not to insisting to Oriya language.
No, whether there are any Sanskrit teachers in the school?
Yes, my lord, I have been prosecuting. We are studying, my lord, we are pursuing that language.
Why, brother? Why do you insist that he should study in other language? Sanskrit is a scheduled language.
Well, it is
in the
compulsory.
constitution.
Yes, my lord. That Odia is also there, my lord.
Odia, other languages are there.
Yes, my lord.
It is his option.
Yes.
How can you compel that Justice Dixit should take only this language, not other language? It's my choice.
Yes, my lord. But since it is where belongs to Odisha, and this
Orissa has more than 61% of Sanskrit words.
that is there, my lord. I am not disputing, my lord, but it is compulsory since 2016, my lord. A regulation is there.
G. G is not here.
Not here.
Same order.
Then call up.
Like the same. But so this today, last year, your lordship, the same order.
You bring G. No, because I want to know. A similar order is already passed.
No, not
in
passed.
item 62.
Your lordships.
What is that?
But that your lordship in that case, my lord, that item serial number 62. Then paragraph as an interim measure, there shall be stay of improved order. Despite the stay of your lordship order, 30/25 annexure 8 and of anterior dates, the student shall be permitted to take interim imminent examination and seek registration for 10 standard subject to the outcome of the petition. That petition.
Subject to outcome of the petition.
So now they are compelling to register Oriya language. Therefore, my lord, this order also passed to them, my lord. Despite your lordship direction,
They are not saying anything.
No,
they have no respect for the court at all.
Not that.
Because many people speak very ill of the court. Even lawyers will speak ill of the court. This is the fate.
They are giving respect in respect of that writ petition.
Call G, just ask him to come. Mr. Lenka is here. Na? Mr. Lenka, what do you say?
My friend was there in this order.
Which who?
My Mr. Lenka.
Lenka was there. Small question. Sanskrit is one of the languages enlisted in 8th schedule. In fact, Dr. Ambedkar said that Sanskrit should be the national language of this country on 9/12/19 in September 1949. Sanskrit is enlisted. Interim order. But that interim order is not being obeyed also. This is what he is saying.
That's
not
item.
Counsel for the petitioner admits that the subject matter of this petition is substantially similar to the one in serial number 62, then WP number 20. So, wherein an interim protection has been granted by the order dated 15/9/2025, and therefore similar protection should be extended to his client who is similarly situated. Personally, there is force in this submission. Next paragraph. In the cognate petition, the interim protection granted by the board is as under allowed 15/9/2025 complete. Next paragraph. It has been the normative position that like cases should be treated alike, and when an interim relief is granted to a set of litigant, the same cannot be denied to the other set similarly circumstanced. First, in the above circumstances, go to that order. The impugned order is stayed and a direction is issued to permit the petitioner. How many?
Not how many? Three
petitioners to take the imminent examination.
No, registration.
To take registration for 10th standard.
10th standard.
For 10th standard, subject to outcome of the petition, with Sanskrit and Hindi as optional subjects.
Yes.
Okay. Solve this matter. 62. We will see that. Yes.
Connected matter.
62 also we will adjourn.
But 62, but in the attachment, complied, my lord.
52 you have complied.
Complied, my lord.
Nothing survives in that.
The complied which they have as per license, as per license,
Registration is already granted. So that 62 has become infectious now. Or you want to argue?
that point, the Odia and Sanskrit.
No, that's the only point. No.
Yes, but that Lordship, whatever Lordship direct.
You take one date and come back.
Yes, madam.
Because what are the consequences, I do not know. Okay. This matter only.
Sub item.
That is sub item, the one petitioner and the first item or two petitioner. Number.
Yes.
Number petitioner.
Well, we'll call this matter next week.
Yes, madam.
Next week.
Along with that 62 also.
Both 62. Bless you. Audience.
Item 33.
Your Lordship, I joined Uttar University as a daily wager in 1988. 88. After subsequent litigation, my services were regularized only in the year 2014 with effect from 2011. In fact, Your Lordship, my representation for antedating my period of regularization was rejected by the Annexure 16 at page 75. But in front of me, Your Lordship, is an order that has been passed by Your Lordship in the month of September itself, where both the petitioner in that case and I case belong to the same seniority list. And many have been regularized with effect from the date of...
From the date of entry.
Date of initial appointment.
That's what. You have the judgment. Have changed your dates and other things.
Yes, Your Lordship. Judgment, yes. It was passed in September and it is identical, Your Lordship. Only thing is he had joined in 97 and I have joined in 88.
Who appears for the OPs?
No, Ramananda Patnaik, TN Patnaik, University.
Patnaik is not here.
No, Your Lordship.
Can you bring him?
Okay. Let me try. Let me see.
Is he passed?
Because I just want to say, Your Lordship, it is totally identical. There is no need.
That's one.
Yes, Your Lordship.
Pass forward.
Item 34.
Yeah.
But kindly see my lord's order, last order.
Yeah.
This is that case wherein regular qualified persons are roaming in the street for appointment. Retired teachers have been directed to continue. That is why my lord have directed them. The total number of vacancies there.
Yes. What is the total number of vacancies they have kept unfilled?
Yeah.
And what are the steps you have taken?
I have already received instruction. So far, the secondary education is concerned in high school matter, and the higher education and university. The information regarding
Kindly keep the mic before you. Let people see what the government is seeing, doing. Yes. What is the extent of vacancy?
Vacancy, Your Lordship may kindly come see. I'm passing on the instruction.
Yes, give that. Share a copy with Mr. Das also.
Yes. I will give. Sorry.
Xerox it and give it to him. Get Xerox that.
Your Lordship will find the vacancy in secondary education. Director of Secondary Education letter. In government school, 5,565. In fully aided high school, 1,652. And new aided high schools, that is block grant high schools, 5,538. And Sanskrit tolls, 502.
Which is the letter which you are reading?
That is 26,300. Director of Secondary Education, you are in the top of the letter.
10-10-25. 10-10-25. He has given. He has given it to me. I have folded it.
These are different, na?
This,
Do you have copy of this? You'll give. You'll get the xerox of them here only. The government is very poor here.
no.
It will not give copies also.
Just now I got this.
Well, you should have asked them to bring 4 copies, 12 copies. So that to whomsoever they want, you can distribute. Like rasgulla.
Sorry,
The rasgullas are sweet, but these are bitter. That's the only difference.
you also got that 10, 25.
Total number of vacancies.
Yes. That is in government high school, 5,565.
That is the vacancy.
Yes.
5,565. 65.
In government high school.
In government high school.
Then
out of total, how much? What is the actual strength?
That they have not provided.
That they will not give. Therefore, you should ask somebody to be here. What the students should do, all substandard students, because substandard teachers, you don't appoint also. I can understand if you do not appoint the police people. If you do not appoint the teachers to the schools, what the children should do? You are spoiling the state.
As it transpires, 13,000 vacancies are.
13,000 vacancies, why they are not filled? Other day, I saw some advertisement of the government saying that our object is to generate employment, let alone generating. Whichever posts are vacant, you are not appointing. That to the schools. If children do not go to the school, and if this is the state of affairs, what is that government is boasting of? Education is a basic need. Dr. Ambedkar said, educate, agitate, and organize. What your government is doing? All our constitution makers will be shivering in their grave. Ask your principal, your chief secretary to be present before the court. Ask him to be present before the court. Why no action is taken for making appointment? 5,565 vacancies in the schools.
In government school only.
It is not only that apart, 1,652
in fully aided high school.
Aided schools. 5,538 in aided high schools.
Block grant. And Shaski tolls 502.
Therefore, 5,565 plus 5,538 plus 1,652. How many? Nearly 13,000 vacancies. Nobody is going on strike in your state. Everybody is happy. Now I understand why this state is lagging behind. I'm sorry to say, as an outsider, I should not say. This is too much. This is too much. What our children should do? All right. What my order said, what steps you have taken about this? What are the steps you have taken? Show that.
In this higher education is concerned, my lord, in the next letter, in colleges, letter 13/10/2025.
Litigation in different court cases. Which are the litigations? I'll get them posted before me now. Give entire cases. You can't just play with the lives of the people. You spend crores together on unworthy things and you don't want to make the appointment to the schools. This is too much. Kindly see the kind of response they have given. Just read it. Let people see. Para 6
of the letter. Kindly read it slowly. I also will read afterwards. People of this state should know what the government is doing. It is further submitted that the recruitment of teachers in government secondary high schools and fully aided high schools in the state is a continuous process.
Yes, sir.
That's settled. Mr. G, come here.
It is further submitted that the recruitment of teachers.
See the vacancy position.
Secondary high school fully.
In no other state, you will be given Nobel Prize. If there is a competition to show we have kept the largest number of vacancies vacant, first prize goes to government of Odisha.
No, we are trying to fill up the.
It's been done. What has been done? This thing is a very elastic word.
My lord, there was an advertisement.
When was the advertisement? Give me the details.
My lord, pursuant to that advertisement, posts were filled up, some cases were pending before your lordship.
This is as of this is 10-10 to 2025. Why wholesale recruitment process is not undertaken? Teachers it is, not some wine shop. Your detergent units, we are not on that. We have no role to play there. Whether you want to appoint, not appoint, it is not much of our concern.
My lord.
When it comes to schools and colleges, because court is the stakeholder, education is very, very important. More particularly, primary education, secondary education. That's how nations are built.
My lord, I agree with your lordship.
Therefore,
but
you agree with my proposal to keep your chief secretary present before the court?
No, my lord. The problem is that, my lord, there are several type of teachers. So far as primary school teachers are concerned, their recruitment will be made through the
agencies.
No, not agencies, my lord. Government is doing that. First, they will be appointed, engaged as Shiksha Sahayak, and thereafter they will be regularized as primary school teachers.
No, that has now been abolished. Now that is not there now. Better now.
Shiksha Sahayak.
Now you are taking a teacher. Initial
assistant
lead teacher.
But the scheme is same.
No. Now it is direct. After your government is come.
Your lordship put a query, what steps are going? That is paragraph 4A of that 10-10 letter.
10-10 letter 4A.
4A, second page.
The other letter?
No, that is 10-10 letter.
Same letter?
Yes.
4A.
Okay.
Recruitment to teaching posts in government.
Secondary schools have been regularly filled up during academic year 2019-20, 21-22, 22-23 and 23-24. Further, the Odisha Staff Selection Commission, Bhubaneswar, has advertised 6,025 numbers of teaching posts for filling of vacancies in government secondary schools. And the certificate document verification of candidate TGT, PCM, CBJ, Sanskrit and PET are scheduled to be held from 16-10-25 to 20-10-25. This is 2 days after marriage. Further, the selection of TGT Arts and TGT Odia and Hindi teachers post has been challenged in the Hon'Ble High Court, and the writ petition is under hearing stage. Additionally, 2,798 numbers of ST/SC backlog vacancies have been submitted to the government for considering filling of these posts in government secondary schools. In the academic year 24-25, 1,798 numbers of teaching posts were filled up in high schools through recruitment by Staff Selection Board, Orissa. Additionally, 1,652 number of vacant teaching posts have been submitted to the government for considering filling up these posts in aided high schools.
Still thousands remain.
No, this just 6,000.
Let us see the arithmetics now.
Now 6,000.
Already about the old estimacy, 6,000 plus 2,700, 8,000, 9,000 and 10,500 are in process.
No, when that will be done?
1610.
No, not all that. No. Kindly see, it is in respect of which schools? Government secondary schools have been regularly filled up.
Yes.
All right.
Yes.
There are 5,565 vacancies as on 10/10/2025.
Yes.
That is last weekend. Yes.
And the advertisement has been made for 6,025.
This was for the year 2023-24. Sir is talking about 24-25. 24-25. But those after filling up these vacancies, again they will make next process for the year 2000.
Correct. You will be knowing the date of birth of the employees. Therefore, obviously, you will be knowing the date of their retirement also.
Exactly.
Date of retirement is not variable, is it not?
No.
It is well known. Rather than the date he gains entry to the service, you will be knowing the date of their retirement. 1 year earlier, in Malik Majir, what the Apex Court said.
Yes.
1 year earlier, you have to make preparation for appointment of the judges' post. Same principle is applicable to these things also. More than code, schools are important. So, this is not the answer. And you have mentioned about the pending case. Where is the state? You have not stated one single sentence about that. Case is pending.
Last week also, my lord has located one.
In today, before your lordship, item 49 also that staff selection. In last week, he also there stayed.
Stay to how many posts?
Only 4 petitioners are there. Altogether, my lord, 700 and odd posts have been stayed.
Exactly.
Still, thousands are remaining.
Yes.
What is you are going to do with those things? You have to file the better affidavit.
Yes. But I have not yet filed the affidavit, only I have
Instruction.
I will file them.
File affidavit along with the steps you are taking for making the appointment. Otherwise, the children of this state will suffer.
Yes.
Other children will prosper. The children of your state will suffer. You want that to happen?
No, definitely not.
I bow down your lordship's concern and we will take care of this.
On which date you are giving full particulars? The action taken report I need.
Yes.
What are the steps you have taken to make appointment to the teaching posts?
So far as 24-25, advertisements have not yet been made.
Not yet been issued at all.
Because
26.
25-26.
And now all these posts are filled up by the retired persons. We have the qualified person, some are going for the average.
They have challenges now.
We are going average.
Fixed.
No, we are going average, my lord. 32 is the last year. I say upper age limit. So what will do? We are qualified. Yes, we are qualified. But these retired teachers are on 25. Because section of the RT Act
24-25, 25-26 it will come. That advertisement has not been made because the recruitment has not been completed as yet.
No.
You have to file better. Keep your. I will direct your chief secretary to present before the court.
Yes, it may not be necessary.
She may give. Let the paper be filed before your lordship. And that second letter, that is in case of higher education.
Yes, there is a mess.
What is the higher education?
That is 13, 10, 25.
Post of VC of 17 university, 15 are vacant. They are not taking. Only advertisement issued, not if it filled out. The
15. Totally how many universities?
17 state universities, as per my record. That is 15 are still vacant. They have issued an advertisement last year. So that they are not taking any step but to fill up, only an advertisement.
Now the governor
post the professors.
The recruitment, previously the lecturers recruitment for the university was with the government. Now that has been
given to the governor.
No, that has been to the university.
University.
Yes.
To appoint
the lecturers and other teaching.
So they have not. But university is government.
Yes, state universities.
Still, government has limited control.
Which control you have?
Appointing authority to university, register and vouchers.
See, if they do not do, suppose if the universities do not make appointment at all, then the government will sleep.
Then we have. Yes.
No, there no appointment made. How many VCs, how many universities, how many regular VCs are appointed? Supreme Court said in Marathawada judgment that vice chancellors are the conscience keepers of the university. Where is the conscience keeper now?
I'll give you one line. Out of 298 posts are sanctioned, they have stated. 298 sanction strength of professor, 260 number of posts are lying vacant. This is the position now.
In university.
Yes. In 98, 260 is vacant. Only 38 professors in 70 universities that teaching the students. What is the situation now?
Though university is not a department of the government, you have abundant power. I have seen the University Act also.
Yes.
You have abundant power
and we
intervene in certain matters.
Yes, yes.
You ask them, why have you not made appointment? What should happen to the students?
And another point I will, your document.
We shall file an affidavit.
You file an affidavit, not just piecemeal.
In 2023, requisition was made to OPSC for filling of the assistant professor post, assistant professor post. And since 2023, the selection list has not been given by the OPSC and the recruitment process.
What step you have taken?
What impression it gives to the people that some business is happening? That will the impression people will gather.
It is all is not in the hands of the government.
Whatever is in your hands.
Staff Selection Commission, PSC, university.
You can ask the universities, because I have seen, I have written the judgment.
Yes,
that the secretaries of as many as 13 departments happen to be the ex officio officers of the members of authorities of the university.
Syndicate members.
Why do you make them? They go there and take rest and take tea, coffee, and maybe taking something else also and come back to the government. That is not the object. Government secretary level officers or in the Senate. Syndicate. Why? What for they are there? For doing maja? That's not the object. So government has put their people, its people there, so that what is happening in the university will be known to the government. Why they are not telling? Why are you keeping these posts vacant? In one advertisement of the government I saw while coming from the airport, the object of the government is to generate employment. What generate employment? There are already vacancies. Why can't you make appointment? Thousands of people will get appointment. That helps the people. That helps the students. And the students are the real future of this country, your state. And there is not even one whisper that you have any difficulty with the funds. Nowhere it is stated. Fund is not a problem. But mind is the problem. Will is the problem. Where is the will?
So you Lakshmi give some more time.
To Chancellor.
Chancellor is also subject to scrutiny of the court.
Secretary to the Chancellor, Lakshmi direct to the Secretary to the Chancellor. I think that all universities, Chancellor is the authority with regard to appointment. Earlier, in fact,
the vacancies is very critical. Can you see there the letter?
Yes. In the earlier, what happened, my lord? Earlier,
90% vacancy.
That was abandoned. That's why matter was pending before the Honorable Apex Court. Subsequent to that was wait, no problem. Now, in the meantime, the all universities they have got the prerogative to appoint their own, but now entire universities are managed by the guest faculties. Is the whole problem.
Total vacancy, they have stated also. Can you see?
So Chancellor, Secretary, all syndicates are there also. In some universities, syndicates are not functioning properly. In 90% universities or syndicates are there, and chancellors nominee and state governments nominee, lots of knows these things. All these are there. So Secretary to the Chancellor, if they'll file an affidavit for the reason for not appointing a professor not to fill up this post, I think that suffice. Sorry, Malak, because of...
No, not sorry. I thank you for assisting. Otherwise, I will be eating your rice, your chapati and your fruits, your vegetables, your ghee and going back after retirement to my state. Nothing will happen to me. But what about I should justify myself that I have been brought here to work. I have to work. I cannot just do some tamasha and go. You have to tell what action, how many universities, you have to tell comprehensively.
That they have stated here.
Yes.
Kindly have a
What action you have taken.
That other
I have
letter,
seen.
1310.
That I have seen that. What action you have taken? You have to tell the court. Next date. If next date, if you do not say that true position, you have mentioned without giving any number of the case, etc. There is a writ petition pending. All right, we will get them posted here. So on which date you are giving full particulars? Why guest lecturers? Guest lecturers who have retired. Why them? What should happen to the youngsters? You send them to Bali Yatra. All young people, let them go to Bali Yatra.
Have a stall and
what is happening? What should happen to the young people? Why are you ignoring the young people? Retired people will get pension. They are happy. We can make use of them wherever necessary is another thing. But what should happen to the youngsters? If they do not get money, how? Well, they will go to the street as pickpocketers.
May I pray, your Lordship?
Yes.
To pass a comprehensive order, it will be better for us to.
I have very comprehensive order. The 23/9/2025.
That was only for vacancy.
Vacancy. What actions have been taken, that you have to state. Why you need orders? You only can do that. That judge is very wrong judge you have brought to Orissa.
Because here your Lordship, the Director Higher Education Secretary, Director Higher Education is not a party. The Chancellor or the Secretary
Government is
not a party.
Government is a party.
The information and statistics data have to be collected from them. I am finding it difficult because sometimes very much difficult.
I mean, permitted to incorporate here also.
So you
either Chancellor and other things.
He is making submission.
Your Lordship may allow the petitioner to make them parties.
I am not allowing. I will direct him to make the party.
Yes.
Secretary to Chancellor, Secretary, Director Higher Education.
And Chancellor, Government.
Why? The Chief Secretary will be the Secretary of all departments.
Yes.
Why all individual secretaries? Under your transaction of business rules, Chief Secretary happens to be the Secretary of all departments, ex officio Secretary. In addition to that, there are other secretaries.
Yes.
You will direct them to appoint the implead Chief Secretary as the party to this proceeding.
And the Secretary to Chancellor also, because for a university.
This court-wide order dated 23/9/2025 had said as under. In partial compliance of the order, learned AGA Mr. Lenka, having made all efforts, had filed the letter of Directorate of Secondary Education number 26300 dated 10/10/2025 and letter of Joint Secretary to Government Department of Higher Education number 54876 dated 13/10/2025. First, in the former, the table is as under this table. You reproduce it. In the later, the vacancy position in the universities is stated as under. I have made it like this. Next paragraph. The information furnished in these two letters fall short of requirement to make any positive order in the matter. First of all, that apart, it is necessary that the petitioner be directed to array the Chief Secretary of Government of Odisha as OP number 8 and the Principal Secretary to the Office of the Governor of Odisha as OP number 9.
Chancellor.
Chancellor. No, Chancellor is not. Oh, OP number, Principal Secretary to the Chancellor of the Universities, Odisha, as OP number 9. First, ordered accordingly. Next paragraph. On the next date of hearing, what are the steps taken by the concerned quarters to ensure filling up of existing vacancies, which are in thousands, should be specified and stated in an affidavit sworn to by the Chief Secretary of the state and also by the Principal Secretary to the Office of Chancellor of Universities, failing which some stringent action may follow in addition to bitter criticism. First off, call this matter on which date?
First week of November.
First week.
Everything is on your computer, na?
Yes.
We'll call this matter on
27th or 28th.
27th we'll call this matter.
Yes.
The holidays are there.
2 days, only 1 day holiday government.
That is my problem. I will say.
This is everybody's problem here.
There are so many departments, universities, so many universities.
Tell which date you want.
First week of November, you will me any day.
We'll call this matter in the second week.
Yes.
Obliged. At that day, if something happens, well and good. Otherwise,
no, it will happen.
We'll call this matter on 10th of November.
Obliged.
May I be permitted to make them parties in the
Yes, I have directed you to do it now. Yes. I have not directed for filing of application. I have directed you.
Yes, I will
implement them now.
Yes.
Yeah.
The next matter, third copy.
We'll come after eating.
Next matter is only.
Madam is not hungry now. You eat your lunch and come back.
Next matter is an amendment. Next matter only an amendment.
Yeah, you file amended. In the meanwhile, you file that amended.
I can file it, but I can make a correction here.
Correction, yes.
Correction I have to do.
Should file the amendment.
I will file a typed copy.
Petitioner to file a
typed copy. I will do the correction here.
You should petitioner to effect the correction to the pleadings and file a comprehensive petition.
Well,
okay. Yeah.
Yes, Miller, item 4, Miller. There is a partner or have this matter, Miller. It is a question of parity, Miller. So the Government of India, Union of India, prohibited by Gazette notification dated 1/7/2025, the page 18. So far, the oil corporation is concerned.
Other cities allowed.
Allowed for 30th September 2025. So our grievance is the petitioners may be
given 3 months.
3 months time.
But that was given in July itself. Notification came in July.
Still now they have seal our go down and notice lordship page 49.
I have a small instruction. We have given ample opportunity. Thereafter, a date has been extended time and again. And
So this is the letter which you share a copy of that letter with me.
I'll file a period minor.
Yes.
In this case, so let's say me give 7 days time. Let's me give you 1 week after any day.
What? Why 7 days, brother? Already it is ready. You have to put it in affidavit form.
Yes, let's make it.
We'll call it on Friday.
Next week.
Monday.
Monday.
On Monday.
Monday is early. Let's me keep it 23rd, 22nd or 23rd. Or 27th is fine.
27th, all right.
Yes, sir.
27th.
Yes,
At the request. Take out another one.
Item 34.
Yeah.
You will pass on the slip minor. Different
Item 33.
Very well. Okay. Yes.
It was that similar matter which your lordships intended to pass as per Ananta Naik's case.
Yes.
So your lordship needed my presence.
Yes. Because I'll say it is a matter is covered with the judgment. So in the light of that, you have to consider the representation.
Not representation. Representation has been rejected. Rejected.
That has
saying that there is no.
You want to take notice or should we allow the matter?
But it would be better if your lordship calls it on Friday itself.
Friday. Mr. Patnaik, the senior panel counsel appealing for the university, accepts notice for respondent 140 numbers 1 and 2. Mr. Behura, who appears for OP number 3, State of Orissa, the DGA on request accepts notice for OP number 3. Call this matter next week, since the same lies in a narrow compass and arguably matter is covered by the decision of division bench. Okay.
No, your lordship's order.
Next week, yes.
No.
Yeah.
The order is of
which I have.
Yes, your lordship has passed.
That's what. Just looking. It is no appeal is filed against that.
No,
not yet. Not yet.
Item 35.
That amendment I have one small amendment I have sought for. I notice I have your lordship has directed to implement the complaint as a party. I have implemented by that first amendment be allowed so that consolidated data placement I'll say.
Correct. An application is moved seeking implement of the complainant who answers the description of proper party, if not necessary party, in the light of Rajia Begum, 1958 Supreme Court Science. First, you appear for whom?
My lord, I am appearing for the BD.
For the
BD.
Then notice has to go to that person.
That person, my lord, only notice will go. They have appeared.
Issue notice too.
I'll take notice by special messenger. He is only in Bhubaneswar.
The parties ought to be repeated. Wide subject application. First up. In addition to taking usual steps, petitioner is permitted to take hand summons to the said party as well.
This amendment, I have sought for a file and amended I have to summons.
No, after when application for implement is pending, amendment application is not treated. Because implement, amendment may happen.
I have only added that, then brought that to the notice of this Hon'Ble Court. The vendor of this opposite party sought to be opposite party has filed a suit that has been dismissed. That has only brought on record. That's all.
That's all right. But let will consider. Correct. Yes.
My cost to be deposited by day after tomorrow.
Hand summons. For hand summons cost is every year.
Yes.
Okay. Very well. For the regular order, you can.
In two cases, my lord, same order.
Same order.
Yes, two
Okay.
cases.
Okay.
Item 36.
Yes. Sure.
The withdrawal was there.
Withdrawal.
No. Withdrawal. Okay.
Item 37.
Meet please, your lordship.
Yes.
57, my lord. I pray your lordship call this matter next week.
Next week, at request of the lady.
Next week.
Yes.
Item 38.
Pleadings are complete, my lord. It can be disposed.
Yes. Maybe next week, what are the papers? Just to think.
Item 38.
Yes.
In continuance to my reply to the counter filed by the opposite party, I am only, my lord, one affidavit, filing an affidavit only on pure question of law, my lord. That I have left out in my reply, my lord.
Yes. Okay. The net counsel for the, you are for the respondent.
I am for the petitioner.
Petitioner has filed an affidavit.
Further affidavit.
Further affidavit to the counter filed by the opposite party numbers 2 to 4.
Which may kindly be kept on.
Leave having been accorded as sought for, the same is taken on record.
Here is the case.
Ready in the matter.
Here is the case, my lord. The issue involved in this petition for allotment of a plot inside the industrial area, my lord, which belongs to the ITCO. In every district, ITCO have been given some area, that is industrial area, where industrial activities
are carried out.
To get a plot
in that area.
Person interested have to apply through online. No direct application is to be accepted. So far as the petitioner is concerned, he has first applied online. His application was rejected on the ground, my lord. Your lordship will kindly see. That is under Annexure 1. At page 12, my lord.
That is dated 18/5/23.
23.
On what ground?
Lordship will get it, page 12. Rejected, dropped as wood-based industry is coming under negative list of the industrial estate, Autonagar, and so is only for auto engineering works and related activity.
Only for engineering works, auto engineering works and related activity. Works is not.
Then I have applied for manufacturing of wood, metal and aluminium furniture.
Is it engineering works?
No, that's why they have rejected. Thereafter again, my lord, I applied on online. That is, my lord, auto. That is, my lord, your lordship will kindly turn to page 15. That application, ma'am. Page 15. Konarko Durga working Swami Balaram. It was rejected because the land is not available.
Yeah, if land is not available, how they can grant?
Yes. It was rejected in 2023. Thereafter, the opposite party number 7
Has been granted.
who has not gone through that online process
Has been granted.
has been granted. My lord, in the counter, the IDCO, on the counter, the IDCO have pleaded that since his case was recommended by the PCCF, Principal Conservator of Forest,
Principal Chief Conservator.
Conservator of Forest, that's why it was allotted. In this affidavit, I have indicated, my lord, that PCCF has no authority to recommend. Only in a case where the persons having the license, which was, my lord, stopped by the orders of the Apex Court TT Godavaran case, thereafter, my lord, they have modified the order, the Honorable Apex Court has modified the order, for which a guideline was issued by the Forest Department to rehabilitate those persons.
Their recommendation will arise.
Rehabilitate the person in the industrial area. So far, opposite number 7 is concerned.
It's not that description.
No. Third submission, my lord.
Your first submission is?
Once they have said that there is no land available.
They could not have land available to you, not to people of that category. People of your category, land is not available.
No, my lord.
You want to interpret it as you want.
No, my lord. In past application, I have applied for wood-based industry.
Correct.
They have said it is negative list.
Engineering.
No, they have said it is negative list. It is engineering. Second, engineering application. No land is available. They have given the opposite party number 7, wood-based industry.
You had applied on which date?
Online, my lord.
Yes.
The application was placed in their meeting under Annexure 1.
You had applied on which date?
Exact date, my lord, I have not indicated. But my case was considered by their meeting, my lord.
That's all right. Suppose if the other side has applied anterior to yours.
The opposite party has not applied online. That is my submission before a lordship. His application was not through online. And they are saying because the PCCF has recommended, we have given him a land.
How PCCF recommended without any application?
No, they have said that they have
applied to him.
Applied to him.
That
is not procedure, my lord. Even if, my lord, there is an application to PCCF. But the PCCF will act if the person was having the license.
That was the
before the banner issued by the Honorable Apex Court. Otherwise not. That is a rehabilitation scheme, my lord. Those persons having the valid license.
We will ask him whether that happened in
third thing, my lord.
Yes.
They have said that in 2019 application, in 2019 the PCCF application, the PCCF has recommended for grant of a plot. In 2019, the PCCF has issued a letter recommending the case of the opposite party number 7, for which he has got 2 plots.
Already one was granted to?
Yes. By virtue of the 2019 letter.
How many units were stopped by the Apex Court decision?
That is 38. 38.
2 of them belonged to the party?
No, by virtue of the orders of this honorable court, he has got that plot.
Under which category?
That my lord, that
Godavarman category.
would be interest. By virtue of this honorable court's order.
Do you have that copy of the order with you?
Hello?
The copy of coordinate bench order?
No, that order is not.
That's required then.
Then my
Because
lord, because I was not a party to that writ petition. Your lordship may kindly grant me some time so that I can.
Correct. Call on 26/11. At the request of the net counsel appearing of the petitioner who wants to produce the coordinate bench order whereby OP number 7 got allotment. 7. 47. Next.
Well, interim order kindly be continued.
Interim order to continue till next date of the
Both the matters only interim order was there.
interim order to continue.
Well, in that matter, I'm sorry, madam. In that matter, appearing to OP number 2 to 4, it go stay.
In this matter.
In this matter.
Yes.
So already I filed my counter.
Sri. So
PK Rao.
Yes.
To his counter, I have filed my reply.
Appearance of Sri. Stand.
My lord,
Yes.
may I pray?
Can I pray you be louder?
Yes, my lord. My lord, can I pray? The date may be, can be
If
fixed.
you want, all the 3 want that date.
Anything, since I filed my counter,
Then your lordship has granted me time to, my lord, collect those documents by which.
My lord, I found down, my lord, but my predicament is that, my lord, can it be on 27th October? 27th October.
Not possible to, my lord, get that order, everything, my lord.
27th of October.
Yes, my lord.
October perhaps we have difficulty. Even otherwise we have difficulty because the calendar is heavily loaded now.
28.
28, 27 that month. Therefore 10th of November we'll have. Any urgency? You are in the position of the problem.
My lord, urgency is that I have already borrowed loan, my lord.
Yeah.
And my industry is yet to commence.
Industry is functioning in the old.
My lord, no, that is
By virtue of this
only set up
which he has done.
I have only set up my sawmill.
We'll have it on 3rd of November. 3rd of.
On that day, my lord, again, if required, I will ask for time, my lord, because in this.
For asking time whether section 11 of CPC applies. Yeah.
My lord, interim order kindly be continued.
Interim order to continue. Yeah.
Huh? Register file कर देंगे ना order है तो accept है लगने
हाँ
it is a further activity your lordship has allowed now they are returning me
no even it is allowed you have to take it on record no?
Give me a copy please. अच्छी
दिल्ली का ना देनी
kindly share one copy with your brother. Yeah. He is my brother also.
Yes.
Yes, sir.
Item 40.
Item number 40, I am from the petitioner.
Yes.
Somebody has filed an intervention petition. I shall have to file an objection to this. I have to inquire.
I filed an intervention.
84 in number
was given to you when?
9th of last week. 9th. My lord. I have to verify who are the persons and file an objection.
Call on 11/11. That's a request of. October very difficult, brother. Yes.
The interim order to continue.
Interim order to continue.
Item 42.
In this case, the government council has taken several times to create instruction and to file counter, but till today they has not filed any.
Well, so we have received instruction to file in form of affidavit.
On 10/11. It's a request of. Yes.
Item 43.
Yes.
Yeah, this is a matter for rehabilitation appointment, my lord.
Yeah. They rejected your claim by order dated October 23.
Yes, my lord.
What are the reasons given there? Annexure A5, go to.
My lord, they have rejected on the ground that the father of the petitioner did not hold a substantive post, my lord.
What's the law on the point?
Yes, my lord. He has been regularized with effect from, that is at page annexure 1 at page 15, sir.
Effected with effect from which date?
That is effective with...
Died on which date?
27/11/2004.
He was regularized in service when?
I was regularized on 16/11/15. And those persons who were regularized, they have already got the pension even.
No, your appointment was also on rehabilitation process.
No, my lord.
No.
No. Now I have...
If father of your client died on 27/11/24, 2004 or 2004?
No, my father died on 2021.
Date till the date?
19/10/21. Then application made in the proper format on 22/3/22 within the time limit, my lord.
It's rejected only on that ground.
Yes, my lord.
Only on the ground that the father was not holding substantive position.
Yes, my lord.
Where is that?
At page 27. Page 27, annexure 5. My lord, found that page, my lord?
Yeah, page I got.
27.
3.
3 and 4 and 5.
Yes, brother, how are you going to sustain this order? He has been appointed, regularized, died. Now, how can you go behind that order of regularization?
No, but the main plank of argument was that he was not appointed in a substantive post. He was regularized under court orders in a superannuary post.
Yes.
And as your lordship knows, superannuary post as per retirement or death of employees.
Question is not to the post in which the deceased was working. If a post which he was claiming were to be that of the deceased, then your reasoning holds water. It is to some other post. Minimum cadre post.
Minimum cadre post, earlier he was working on daily wage basis. Thereafter regularized as per court order.
Covered by it. Right. Petitioner, an aspirant for the post on compassionate ground, is knocking at the doors of Great Court for proceeding the order number 9904 of 2023, dated 20 October 2023, a copy whereof avails at Annexure 5. Vasanto. First. Learned counsel for the petitioner submits that the impugned order suffers from an error apparent on the face of the record in as much as the claim for compassionate appointment has been rejected on the ground that his or her, his father, petitioner is a she or he?
He.
On the ground that his father though died in harness, was regularized in service against a vacancy in a post created on ad hoc on a supernumerary basis. First one, she also points out that.
My lord, can I clarify, my lord? My lord, these posts are not supernumerary posts.
Anyway, he's saying that.
My lord, I have annexed in the scheme, in my rejoinder, which shows that these posts are not supernumerary posts, my lord.
But that is the case of the opposite party.
That's what they have stated in the impugned order.
Yes,
She further points out that, firstly, on the principle of law, such a contention is not maintainable. And secondly, the contention is factually incorrect, in as much as the post held by the DC was not supernumerary post at all. Next paragraph. Learned senior panel counsel appearing for the answering OPs opposes the petition, making submission in justification of the impugned order. First one. He also tells the court that the right to compassionate appointment is not unconditional, such appointment being an exception to the rule of equality. And therefore, interference of this court is not warranted. But having heard the learned counsel for the parties and having perused the petition papers, this court is inclined to grant indulgence in the matter, in as much as, admittedly, the services of petitioner's father was regularized on while order dated 16/11/2015 with retrospective effect from 27/11/2004, along with the other candidates. First off, whether such a regularization was made by creating a supernumerary post or not, is irrelevant, in as much as to such a post the claim is not made for compassionate appointment, but it relates to some other post in the lower rank in a normative process. First, the contention that when a supernumerary post is created for appointment, on the demitting of office or death of the incumbent, the post comes to an end, does not assume importance at all. First now. Next paragraph. In the above, the next one. It hardly needs to be reiterated that the compassionate appointment is given to the family members of the DC to overcome the difficulty which death ordinarily brings in death of the breadwinner brings in. First, the claim for compassionate appointment has to be treated with compassion. First time. That is not reflected in the impugned order. Apart from its being bereft of law and justice, elements of law and justice. First, in the above circumstances, petition succeeds. The writ of certiorari issues, passing the impugned order. Third, the writ of mandamus issues to OP numbers 2 and 3 to grant appointment on compassionate ground to the petitioner within a period of 8 weeks and report the same to the Registrar General of this court. One more ground we have to say about this. Ordinarily, when rejection order is set aside, comma, matters of the kind are remitted to the portals of the authorities for consideration of question. However, that procedure need not be followed in this case, in as much as the only ground on which rejection of the application for compassionate appointment has been structured is the post being supernumerary and regularization of the deceased employee being in terms of the order of coordinate bench of this court. First of all, there is no other reason. First off. Therefore, other reasons now or afterwards cannot be furnished by the authorities in the light of Mohinder Singh Gill versus Chief Election Commissioner, AR 78 SC 851. Structure it there. Yeah.
Item 44. Item 44.
Yes.
Here, the petitioner refers to be a retired employee, not getting pension, and it's a 3 is impugned, and it is almost all covered matters. Yes.
Except 3.
Yes, so it's very small matter, also covered matters. Annex 3 is impugned.
What is that?
Well, here the question is not just I'm pressing the facts. There are also after I got in the issue. Here, the petitioner an employee upon initially employee upon aided education institution, and subsequently became the government employee after the management of school has taken over by the governments. The government in principle in the year 1994 took over around 3,000 schools, management of 3,000 schools. And initially they were the aided institution employee and subsequently became the government employee. With effect on
slowly. One sentence after that you have to put a full stop because larger question is involved now.
Yes, yes. Here the question is, my lord, the petitioner was initially an employee of an aided education institution.
Understood. So that institution was taken over by the government.
Along with around 3,000 institutions.
Therefore,
and the petitioner became the employee, government employee.
That
with
is there I'm finding.
Yes, yes, I will satisfy. With effect from 7/6/94.
Yes.
Then the question comes for the government, how the cadre of the 2 set of schools were merged. That comes up before the government.
Regular government employee.
Regular government employee and taken over.
Afterwards taken over.
And the government in principle decided that 50% service of the pre-taken over period is to be counted for the purpose of seniority. That record is there. I mean, satisfying analysis. That 50% service of the pre-taken over period, that means aided period, that is 2:1 ratio. 2:1. 50% service of the aided period will be counted for the purpose of seniority. That's I got the point. Suppose I rendered 94 take over, 84 my appointment. So 10 years I will 5 years will be counted.
5 years you will get.
Yes, that is acceptable. No issues. Then accordingly we are given almost all benefits, revised scales under 98, 2008, SCP and the RSCP. Now the question comes for RSCP. And in the 2013, the government introduced the RSCP principles. After 10, 20, 30 years of service, when there is stagnation promotion, I will get one increment. And actually that was given to me. And I was allowed to retire on superannuation. I also retired. But the question comes, my lord, in the year 2017, the government issued a circulars, letters saying that while granting this RSCP 10 years, that has to be counted with effect from the date of the getting seniority. That means the 50 years service has to be counted, not the 100%. But you got the point. That is the question. The 50% service, whether the 51% service.
One second. What you say, the discount of 50%.
Yes, my lord.
That is not applicable to your RSCP benefits.
As per the government. As per the government, the government says that the 50% period that was given for the purpose of seniority, that will be taken into consideration for giving the RSCP, not the full. Suppose my appointment I was appointed in the.
You say what is applicable to
seniority.
Fixation of seniority.
That is applicable. No, that is applicable. That is applicable to the RSCP. That is the government circulars. I challenge it. One of my similar person challenge for the tribunal. Tribunal quashed it, saying no. That is in respect of seniority. But for the purpose of fixation of seniority, that cannot be counted for the purpose of RSCP. So give it.
In other words, for deciding grant of RSCP, the entire service should be counted.
That entire service should be counted.
Including the pre-takeover.
Pre-takeover periods. From the very beginning where I am getting granted it. That is not. Then the state went to appeal for the division by the honorable courts. And that was rejected on merits, saying that whatever the tribunal passed, that is confirmed. Then the state went to the honorable apex court. Again, that was confirmed. Again, then different writ applications were filed, hundreds of writ applications filed. Now, almost all cases, different coordinate bench pillars passed the similar orders. And the government, in principle, decided to give the benefits. And accordingly, the benefits are given to all those who obtained the court orders. Accordingly, hundreds of cases were filed, and almost all they are getting the benefits. In my case, my lord, now you see the impugned order, what they were stated. Now, the control of account, referring to the government letter which has been passed by your lordships, saying that the 100% service counted for the purpose of RSCP, that should be deducted, 50% should be given, and accordingly revised. You also kindly see Annexure that in tune. Annexure 3.
Annexure 3.
Annexure 3. Again, they said they follow 2:1 principle. Though in government on principle say no, 1:1 is required. Pursuant to Supreme Court judgment, that I am giving, that is there. That is also on page 19. That is the government decision.
Page 19.
No, page Annexure 3, page 17. Also, kindly see what is impugned order.
You are very fast. I am little slow.
Sorry, sir.
You have to take me on the garden side.
No, sorry, sir. I am extremely sorry. Control of accounts, Odisha, page 17, Annexure 3.
Annexure 3.
Yes.
Controller of accounts.
To the district education officer, Malkanagi,
clarification.
Clarifications. In pension case, you got it, pension case. In inviting a reference to a letter such and such, I am directed to return here with the pension papers and service book of such and such. Point 1. As per the clarification issued by the government, such and such, the admissibility of a third RSP not followed with ratio 2:1, which may be rectified. Then the other consequential benefit that is there, excess payment and allowance along with the unutilized.
Number 3, excess payment, etc. is not the issue.
No, that is consequential. That is consequential. If you also say nothing.
Point number 2 is the factor.
The pay of provisional such and such has been fixed on the with effect on such and such instead of such and such, which may be re-examined. The point 1 is similar issue. Only whether that is 2:1 or 1:1. If you also say 1:1, then the consequence that will go. And if you also say no 2:1, then that will continue.
2:1 means?
Again, Millers, whether the 50% service will be counted or 100% service. That's the issue.
2:1 it is. 1:1.
No, the honorable court said 1:1. Initially, the government said 2:1. The government said that the seniority for the purpose of computation of service period towards RSCP, that the date of seniority will be counted. The seniority for fixing the government, so far as seniority is concerned.
Norm for fixing seniority is one thing. The norm for granting RSCP benefit is another.
Another thing.
For seniority, 50%.
Yes.
50% of pre-takeover service.
Yes, Minister.
For RSCP, entire service.
Entire service.
That is the law declared by the
honorable apex court. By the confirmed by the honorable apex court. Then you'll also kindly see page 7, next page, page 18, which was impugned for lordships in the tribunal. Kindly see that is the original letters. 23.
That itself is set aside.
That was set aside. I'm just giving the judgment is there. Let's kindly see this. What is the paragraph 1? The period of service for RSC benefits
of the employees of
the taken school shall be counted from the date of employee counts it for fixation of interest seniority, the date of promotions. So that cadre, fixation cadre, that the government said that should be given. That means the 2:1 ratio has to be followed. I question it, and that was questioned. So kindly see the judgment and confirmed by the honorable court and honorable apex courts.
You have said that I believe you.
No, that is confirmed, and not one judgment. There was bunch of records where she passed these orders.
Different of judgments.
No.
Is it covered by the
Oxford Mahapatra case also kindly see.
Why you are arguing so much when he is saying it is covered by?
I am nothing to say, you can cross it.
My lord, say it depends on the facts and circumstances. The principle is decided there, but I think I should file a counter so that it can be decided.
I am not getting.
Otherwise, he may approach and his case may be considered in terms of.
That will do justice.
Yes, my lords. Your lordship, you have now got the entire picture, my lords. And I want justice, and the person is now getting pension. Not getting pension, and pension was returned by the control account, saying that to revise it by applying 2:1. Though the 2:1 principle has already been declared.
That appears to be wrong, Mr. Behura.
My lord.
The controller appears to have gone astray.
Let's.
How we can say that when already my issue is decided?
I have not received the instructions, my lord.
No, even otherwise also it is available. Anyway, all right, you consider in the light of that decision. Huh?
The Honorable Court passed the similar bill. Only one line order. Different judges of the Honorable Court have given.
Provided it is covered under that.
Provided that is there. And the interestingly, also kindly see the last annexure where the government also took the decision. Also kindly see the government decision is there. Page 19.
Government implemented orders of the court.
Implemented. And they said that should be implemented. And according to that giving the benefit is given to almost all persons.
No, if you permit, I will grant the. Kindly please see. A retired employee is grieving before the report against non-sanctioning of his terminal benefits, more particularly the pension, on the ground that some issue relating to reckoning of his pre-takeover service has cropped up. First time. Learned counsel for the petitioner submits that as per the extant government policy, the service rendered by aided educational institutions prior to they being taken over by the government was liable to be discounted. Semicolon. The same having been the same principle having been applied to the cases relating to other than seniority issues, the benefits were denied to the employees. Semicolon. That was the subject matter of writ petition number, which is that? Not writ petition, that private.
Both copies are there. Both writ petition and Supreme Court judgment, all are there. This are there. I could have tribunal first.
Subject matter of dispute in OA number 1668 of 2017 between Ashok Kumar Mohapatra versus State and others, disposed of on
9/10.
9/10/2018. 2018. In favor of the employees of the kind. That was put in challenge before a division bench. Division bench?
Yes, sir. That is the copy.
A division bench of this court in WP number
6698. That is there.
6698 of
2020.
Which came to be negatived by the order dated
13/3/2020.
The challenge was further carried by the state in SLP number.
Special leave to appeal C number
15573 of 2020. And the same came to be dismissed by the apex court, wide order dated 4/1/2021. First, counsel submits that being the position, the controller of accounts Odisha is not justified in returning the pension papers to the district education officer while impugned order dated 21/5/2024. A copy whereof will set an exemplary. First up. Next paragraph. Learned AGA appearing for the OPs vehemently opposes the petition, making submission in justification of the impugned order and the regions on which it has been constructed. First, he contends that although pension is not a bounty, the grant of pension is done on normative basis, and therefore, unless the norms are strictly adhered to, claim cannot be favored. First, next verse. Having heard learned counsel for the parties and having perused the petition papers, and also having adverted to the judgment and orders of Orissa Administrative Tribunal, followed by division bench of this court and affirmed by apex court, this court is inclined to grant indulgence in the matter as under and for the following reason. First, next. Pension is not a bounty, said the apex court in Devaki Nandana Mishra versus State of Bihar, followed by D.S. Nakara versus Union of India. First, the short issue involved in this case relates to counting of pre-takeover service. First, for the purpose of seniority, true it is, 50% of pre-takeover service is counted, whereas for all other purposes, the entire service has to be counted. Is the jugular vein of the judgment cited before this. First, therefore, the controller of accounts is not justified in structuring his impugned order on region numbers 1 and 2, although the reason number 1 may be required for examination, may require examination at the hands of government of the jurisdictional authority. First one. Next paragraph. To put it succinctly, comma, for the purpose of determination, fixation of pension and other terminal benefits, comma, the service of an employee from the entry point has to be reckoned, correct? From the date of entry into service.
Can I say something else?
Yes.
With due permission. Here the issue what I was also saying, I think that is not correct. Here the issue is Miller, grant of RSP.
Yes.
Whether the ratio is 2:1 or 1:1. Your Lordship said the grant of RSP on the basis of 1:1. And accordingly RSP was given. And on the basis of last paid on, I will get the pension. Whether initially or lastly, that is not the issue. Issue is whether the grant of RSP on the ratio of 1:1 is correct or not. Your Lordship said that yes, it is correct. Now the control account said no. You again, which was passed by your Lordship.
Restructure. To put it succinctly, comma, the controller of accounts cannot go behind the allocation of RACP benefit on the principle of 1:1.
As per the decision of the Honorable Court.
In the light of decisions cited above. First off. Therefore, that portion of the impugned order is liable to be set aside, comma, keeping the other intact for earliest examination. Next one. In the above circumstances, this petition succeeds. Semicolon. The writ of certiorari issues, quashing the, where is that? And there 3.
The next 3 minutes.
Quashing. Point numbers 1 and 2 in the impugned order dated 21/5/2024, coupled with a writ of mandamus to
re-examine in the terms of
but in time-bound way. To accomplish the task of sanctioning and releasing the pension and terminal benefits to the petitioner within an outer limit of 3 months. Comma, the first one. It is made clear that point number 3 in the impugned order of the controller of accounts has to be examined by whom? By the district education officer on its merits within 1 month. Within 1 month it should be done. Within 3 months pension should be this one. Yeah.
He's getting pension, my lords.
Yeah, but the variation happens.
Only variation.
Not getting also.
Oh. Why retired? And you also see Annex 5 is a government decision. So government has already taken decision. Kindly just look at Annex 5. Just all result. Kindly see Annex 5.
Keeping in view the decision of the government at Annex 5. Over. If that is kept in view, yes, rest of the things will fall in place.
You'll also directed the control account or the DO?
Controller of accounts, the 2 have struck down now.
Yes.
Only 3 will remain.
That is consequential. That is revise that will revise.
No, but that 3rd should be considered.
No, sir, no, I say no. You have whatever said right. But let the direction let the direction issue to both control of account and the DO.
Both.
Then also can say both the opposite pattern number.
District education the 4. No, he is 4. He is 3.
DO 3 and control account 4.
Controller of account 4. Yes,
enter the DO time and again DO recommended. Now the control account paying similars.
No.
Item 45.
Please, Your Lordship.
Yes.
My Lord, I'm appearing on behalf of Mr. Nihal Rath. My lord, we have received the counter on 11/9/25, my lord.
What you want?
I seek some time to file the rejoinder. 1 week time may be granted, my lord.
1811. At the request of. Those judgments we need, no?
No, only the reference judgment, the certified copy. I have already given the judgment of Honorable Appellate Court, High Court, and the tribunal. But the covered judgment, consider according to also of the guest, some certified copy are there. Only
copies are there. Certified written.
All right. I will take it later on.
Afterwards you can
All right. No problem.
Afterwards you will. Possible. Yeah.
Item 46. Item 46.
In that case, my lord, the lordship was pleased to send the
commission.
System today submitted the report.
Whether payment is made to you, Commissioner? Not yet made.
I believe
you have deposited that money in the both you have deposited.
Well, prior to vacation.
I believe to complete my task thereafter.
Then you want to take it.
Your Lordship, with your Lordship permission, on 10/9/2025, your Lordship pointed out two things. One, whether any unauthorized erection of certain structure is present in the stealth floor, and second one is about some unauthorized parking of vehicle, your Lordship. So far as our spot, we went and to the spot on 7/10/2025. We found there is no such unauthorized erection on the slip floor, but in front of the office room there are two walls, small walls facing each other. And verbally, we had a conversation with the flat owner. They stated that the office is situated since the time of the building, but they are on the street wheel. They are not going to that office. The second thing is that, your Lordship, there are 8 flats in that building. And
only 8.
Your Lordship, and some of the flats are rented for commercial purpose, your Lordship.
That's not the issue.
Your Lordship, why I'm coming to the issue, why I am saying about commercial purpose, your Lordship, the flat was allotted to a family with 5 members. I have also collected their sale deed. Why I will come to it, and I have also filled up a form for verification purpose. What is there? Your Lordship,
they should. That form is there. Be seated. All others be seated. Because
the building
is the extended arm of the court.
No, that's there on record. I said that.
The building was for the residential purpose, so it was limited for some person. But now, when there is a real estate business going on by some Pratik Gupta, I have also annexed the photographs. There are 10 to 11 employees are there, your Lordship. Thereafter, a hostel is also run by one of the flat owner, where 10 to 15 people are staying in the hostel. And airline service is also functioning in that building, your Lordship. So what I want to submit before your Lordship, the flat was confined to 5 members of their family, one flat. Now in one flat, 10 to 15 people are coming, and they are parking their vehicle in that, your Lordship. That's what I want to say. So those vehicles are regarded as unauthorized parking.
Okay.
And to that effect, I have also collected some sale deed to see the purpose. What was the purpose of initial purchase? When the flat owner purchased the flats, what was the purpose? It was purely for residential purpose.
Is there in the sale deed?
Your Lordship, it has been mentioned. It is in a bulk, so I have not annexed it. And beside that, your Lordship, there is another document which was supplied by one of the, I think, by the builder here. And one most important factor, your Lordship, may kindly take, there is no society. if there would be any society, then if the society
association.
Your Lordship, there is an office. Everyone admits that it is an office for all the flat owners, but they have admitted that we are not going to that office. There was a format of rule and regulation which I have enclosed at enclosed 1.
I saw that.
Your Lordship. Here, all the flat owners have given their endorsement, but this is not in force, Your Lordship.
Not in force.
No.
Why?
Not in force. Actually,
not being implemented.
Your Lordship. That's what. It is not implemented.
What about that old car of Victorian era?
Yes, that is of.
There is one.
Yes. That is the petitioner stated that it is his car, but the condition is not in a running condition. Your Lordship may see.
Yeah.
It is also there.
But so many vehicles have been, two-wheelers have been, they belong to the student. Hostel mates.
Hostel mates and the person who are employed
by other people who are running business there.
Your Lordship.
Who they are running business in connivance with whom? Is it true? Madam, any business is being run there?
No.
Otherwise, how so many vehicles will be parked out?
Let me put this thing.
I have stated that.
That senior, in spite of request, you are not handing over those affidavits. I have thrice personally requested, please hand over.
I'll supplement.
What kind of advocacy? I do not.
3 occasions I have asked my learned senior.
That affidavit, my lord.
And the
give first. We should give everything. This is not the Remy game, where we will hold back the cards and ask the other side to be the victim. Both you have deposited how much money there?
7,500.
7,500 each.
Each, madam. Each.
The commission consisted of 2 members.
2 members.
Yourself and that madam.
Okay. And that can also be interim.
That's interim only.
Yes, madam.
Only for that yes. Other thing. Otherwise, nobody will come forward for the commission at all.
Interim in the sense that amount is not final.
That's what.
That's it.
They must. That's what.
Because
that I will fix now.
After 2 days,
excellent job.
After 2 days of curfew on 5th and 6th, they could venture to go Bhubaneswar. That is
I do that.
But your Lordship may appreciate that. This is one affidavit. Another affidavit.
Have you got the copy of the commission report?
Just now I have got.
You have got that?
Just.
Very. Now I will also look into that. You also look into, come out with your response. In the meanwhile, each one of you deposit 7,500 again. And totally 15,000 each commissioner will get.
Yes, madam, this should be. He was also thinking this is petty, small amount.
You can give more also if you want, no problem. Court has to be very
off record. My sister used to. That's all different. I will take specific instruction about the hostel and anything, whatever.
Just look into.
Yes, madam.
First, let them get back that whatever done, should appreciate them. Yeah. Go to our order.
One thing, my lord, in that report, at paragraph 3.
Then we look after first, you give serve copies.
Yes, I have already.
Let me one affidavit. What is the another affidavit? GH or something like that.
How many pages it is? Other affidavit is.
No, other affidavit I have with me, but on the last date when your lordship was pleased to appoint the commissioner, that is why perhaps it was not filed. I have not verified. If it is filed, I will hand over the same in course of day. I have the copy with me.
Whatever affidavits have been filed.
Yes, sir.
Give Xerox them and give one full set to.
No, I have with me, man.
I have one set. If it is filed,
yes,
that is he not give.
No, that is I have perhaps it has not been filed because the original is with me.
Just verify whether it is filed or not.
one affidavit I have filed.
It might be because stamped affidavit.
Yes, that was prepared on that to be filed. Since your lordship was pleased to appoint the commissioner, it was not filed. If I file it along with the copy, I will file. I have the extra copy.
This court wide order dated. Where is that order? Go to the last order.
23rd line.
That's E and J. These to be solved. Yeah. Dated this order, wide order dated 23/9/2025, had constituted a commission comprising of 2 gentle members of the bar, namely so and so, Srimati so and so, Srimati Kumari, whatever, just look at it. First off, the commission has accomplished the task in a time-bound way and in an appreciable manner. First off, having accomplished the task, they have placed on record a copy of the report dated. You have not put the date to the report.
Yes, I have annexed the
2025. Correct.
Sister is filing today.
Dated 13/10/2025. Yes. Report is dated 13/10.
Report is 7/10. I think no.
It cannot be 7/10 because many statements are taken afterwards.
Yes.
He has visited on 7/10.
Yes. Dated
7/10/2025.
No, you have put signature also 13/10.
13/10 is today. I have served the copy, whereas the spot visits were done on 7/10/2025.
7/10/2025.
Yes.
After serving copies thereof on both the sides. Both the sides. First off, this court places on record its deep appreciation for the works done by Srimati so and so, Srimati so and so, as the members of commission. First up, the registry is directed to release the amount in question in equal proportion to the commissioner on the production of this order, on the production of a copy of this order. First off, the next one, the above apart, the petitioner and you are which respondent?
My lord, I am for
OP number
7, 8, 9 and 11.
Petitioner on the one part, petitioners on the one part, husband and wife.
Builder is the only
one,
not the
on the one part, and OP numbers
7, 8, 9 and 11.
7, 8, 9 and 11.
Fourth part
on the other part shall pay each a sum of rupees 7,500 to each of the petitioner, each of the members of the commission.
15,000
15,000 each. That accords with the what they have done. And the festival is also coming now. Within 1 week. Within 1 week.
Yes, no.
Without breaking any deal. By check. By bank
check. We are depositing in our High Court. There is account.
Instead of that, you give them.
I was also proposing directly. Yes. I can. That's better.
Each one of you will pay that amount.
Directly will pay.
Directly.
Okay. Online.
Next paragraph. Call this matter for further consideration on 1811. 1811. First up. In the meanwhile, both the sides may file their reply to the commission's report. Commission. So far, after serving copies on each other.
The interim order is there, that
interim order to continue.
So far as the affidavit is concerned, one copy I have already handed over.
The other copy also
I will take up qualified.
So
The last application filed on 11th September.
Last one?
Last one filed on 11th September.
11 September you have filed.
That copy I have already given.
No other
Prior to that,
affidavit?
another affidavit was filed when your lordship wanted to know about the
This was of 29. The 22 ନର।
ସେଇଟା କହିଲେ
22 ନର। ଆଉ ଗୋଟେ 11 ନଅରେ ଫାଇଲ କରିଛନ୍ତି।
Anyway, your friend will give.
Yes, I will give.
How he will retain copy?
नहीं।
What benefit he will derive? Please give the copies. All right. Yes. Thank you so much. Registry shall share a copy of this order with the honorable commissioners. Hello, free copy.
Will it be possible?
Will you make it part of your weekday? Your what do you call that day?
Weekend.
Huh? What do you pronounce it? How you pronounce it in your state? I don't know. CV. Ask.
Will it be inappropriate on my part to ask for a copy of the pen drive?
Yeah. Pen drive there, na?
My sister.
You give one pen drive. The one pen drive you have given here. Each one of them you give a pen drive at their cost.
Yes, ma'am. I supply they will copy.
Yes, they will give that. All. And celebrate the festival very well. Yes.
Item 47.
Right, please. Shipala petition of the assistant teacher in a primary school and transport to different school. And transport to different school.
My lord, the lordship wanted instruction to be received. That I had not. New DEO has come. I will get that instruction.
You get.
And it come next week.
Next week we have difficulty, na? We have posted many matters.
My lord,
this matter on 2310.
22nd, yes.
2310. At the request of the email. Yes, next.
Item 48.
As per your lordship's order, district medical board has examined my deformity, but the report officially is not supplied to me. So I pray after vacation, your lordship direct district medical board, but they have examined. So the required percentage also they have assessed. Only to official letter be produced.
They have not sent letter as yet.
No. As on that.
In terms of order dated 1/8/2025. 1/8/2025, comma, it was submitted at the bar, comma, the medical examination of the candidate has already been accomplished, and therefore the report in a sealed cover is to be reckoned, is to be received from the medical board, district medical board. Palaso. First off, registry to send a reminder to the said board in that connection immediately. Call this matter on 24 on 3/11. Yes.
Item 49.
Item 49.
For the petition.
Yes.
File interception till
in similar matter. In similar matter.
No, people
Yes.
other petitioners. But let the petition.
Yes. My preliminary submission before your lordship is at the instance of the 4 petitioners.
Petitioners, all 600 or
711 post has been stalled.
That is what
in similar matter, your lordship modified that order. Yes, relating to some other subject.
Our case is different.
Yes, let them argue. And they have participated in the selection process.
Can be taken up forward. Double petitioner 16409. Yeah, kindly taken.
They have participated in the selection process. Yes.
Now I am asking you, if your 11 posts are kept vacant,
only petitioners.
Clarify,
If that, with respect to the submission made by my learned senior, I would like to submit, my lord. If the suggestion your lordship is advancing is accepted,
then the net result would be countenancing an otherwise illegal selection conducted by the commission, not by the government, in the process by violating their own terms and conditions as has been fixed in the advertisement. Here the main issue is, can the commission, who is the examining body, violate the terms and conditions fixed by itself in the advertisement in course of the recruitment process, and do something when the advertisement is conspicuously silent about a relaxation clause whereby a power has been reposed on them to do it. That has already been answered with your lordship's wisdom. But several judgments, including the latest constitutional bench judgment in test
I have brought.
Your lordship knows, my lord.
Yes, sir.
And my lord, I will place how you will be
agree.
Yes, your lordship. Yes, my lord. Now your lordship kindly see. My lord, the advertisement was issued for 711 posts. In the advertisement itself, under clause 4, it has been clearly delineated what would be the plan of examination. Plan of examination prescribes that where against there are 8 categories of posts which are advertised in that particular advertisement. A general condition has been imposed that as against any individual post, wherever the total number of candidates applied for is 5 times more than the number of posts advertised, then there will be a preliminary examination conducted for the purpose. With this condition in place, the commission conducted the preliminary test in respect of 4 categories of posts, but in respect of Hindi teachers, they have clearly notified that they will not conduct the preliminary test, even if the total
number exceeded.
Number exceeded. This is one. Second thing, my lord, in the advertisement itself, it has been stipulated that in the main written examination, whoever will be allowed to who will be allowed to sit at the main examination? Only those who qualify in the preliminary test, and the syllabus for preliminary test is completely different. It is not subject. It is the general the aptitude of a person which will be tested. If your lordship will permit, then I may just bring it to your lordship's notice. What is the criteria, what is the plan of the indicative syllabus for preliminary examination? Preliminary syllabus examination comprises of general studies, which includes Indian Constitution, Indian economy, Indian geography, history of India, history of Orissa, general issues of environment and climate change, 10th standard. It is up to 10th standard, arithmetic 10th standard, logical reasoning and analytical ability, general mental ability, computer and internet awareness, current events of national and international importance. So this is the syllabus prescribed for holding the preliminary examination, which has been skipped specifically in respect of Hindi teacher post, even if the terms and condition requires that they should have done it. And my lord, what they did, my lord, so far as the main written examination is concerned, it has been clearly said this preliminary examination is qualifying. So if number of candidates will not qualify in these preliminary examination, naturally the number of candidates who will ultimately be asked to appear at the main written examination will be less. And my lord, it has also been stated that while sending persons or shortlisting persons for main written exam who will be ultimately allowed to sit at the main examination, it will again be arranged on category-wise breakup basis, and 5 times of the total number of advertised vacancy in respect of each category will send for the main written examination. Now what has happened? Everybody, even if persons who could not have selected in the preliminary examination, now everybody has been allowed to sit at the examination, main examination. And again in the main examination also said.
Yes.
We are also participated. The question is who the intervener is. Since my lord senior is intervening with begging pardon, my lord, and praying liberty from your lordships, I am saying, who are these interveners?
We are the participants.
Just a minute.
We are the
When the issue is very clear, even the selected candidate doesn't have any right. What about the persons who are only candidates like us, and in respect of whom no result has been published, making him a selected candidate in any select list prepared so far?
You said
result has been published.
First one is that they ought to have conducted preliminary examination, which they did not. This is number one.
This is number one. And number two is the decision to not to go for this preliminary examination is impermissible in law because no such provision of relaxation is available in the advertisement itself, which has been said to be, which has been exercised by the examining body in the process. So that having not been there, because the law is clearly set in this regard that if the advertisement or the rule prescribes that the relaxation clause, then only they can exercise the same and do it. Here they have not. There is no relaxation clause available in the advertisement.
Go to the next one.
And the next is by doing so, the
first point canvassed by the counsel for the petitioner is that when the advertisement specifically prescribed a preliminary examination, if ratio of applicants exceeds 5:2,
that 5 times of the total number of advertised vacancies.
5 times the total number of vacancies.
Yes.
Yes.
Come. Here, my lord, the facts which needs
first one. He also points out that there is absolutely no provision, either is a subject to extant rules or in the notification, which gives discretion to dispense with preliminary examination. Number one is over.
Your lords may kindly see the fact here is total number of advertised vacancies were 700.
It also points out that apparently the number of persons who had applied had exceeded that quota.
My lord, that is what my lord, the figure I am giving. Total number of advertised vacancies were 711. 5 times of the 711 comes to 3,555. In the present case, total number of applicants as per the admission made by the commission, who is the examining,
said that it is in excess.
4493. The facts I am supplying, my lord. So
I will look into all
yes, that is what I say. Correct.
Yes. Next.
Yes.
Second point.
Next contention is even if they have hold the written main examination allowing all, there also they have deviated the advertisement condition. Why I am saying so? The advertisement prescribed that the main written examination will be conducted with 150 marks, with a paper comprising of 150 marks, and out of which pedagogy will be one of the limb of examination. Pedagogy and evaluation will be one of the
parameters
of examination. And there, the advertisement specifically prescribes that the questions will be asked both in bilingual mode, that is, both in English as well as in Hindi. But while conducting the main written examination, what the commission did is, commission has conducted the main written examination only with Hindi as the language, without asking the questions, without putting the questions in English. This is what they themselves have deviated upon.
Where is that?
My lord? Yes. Your lords may kindly come to Annex 4.
You can put up the mic. It does not need mic at all.
Because yes, my lord.
I appreciate that. I appreciate that. At least that energy is being.
My lord may kindly come to running page 25. 24 and 25. No, second, your lordship is holding the brief of second case, sub item WPC number 16409 of 2025. Then your lordship may kindly come to running page 24. My lord, kindly see clause 4. plan and pattern of examination.
Yeah.
My lord, there are 3 stages about which I have referred to. The first one, your lords may kindly mark. Preliminary examination, objective type MCQ, 1 paper, marks allotted 100. It is qualifying in nature. Preliminary examination will only be conducted for such posts.
Hard copy.
Your Lordship may take up the second matter. He is referring to the second matter.
That is what I have said.
Yeah.
1640.
Second matter.
My lord, may kindly come to running page 24.
Qualifying in nature.
Yes.
Where it is.
The preliminary examination will only be conducted for such posts where the number of valid applications are more than 5 times the advertised vacancies. Then, my lord, stage 2, main written examination, objective type, 1 paper, 150 marks. Then your lords may kindly come to next page, running page 25. Your lords may kindly come to running page 25, the next page.
Totally, how many people applied?
4493. As per the affidavit filed by the commission, who is the examining body in the present case and who is the author of the advertisement itself.
4493. Five times would be how much?
3555. Because 711 are the total number of posts. Which your lordship can very well get at running page 16. The total number of posts your lordship can very well get at running page 16 of the brief. Your lordship got it?
Yes.
Then your lordship may kindly come to running page 25. Running page 25.
Yeah.
Since we are concerned with the post of Hindi teacher, your lordship may kindly mark the full marks is 150, 1 paper. I had already shown to your lordships. And my lord, right hand side column, extreme column, your lordship may kindly mark. Subject is pedagogy and evaluation. It is English and Hindi, Roman script and Devanagari script. Your lordship got it?
Yeah.
Then your lordship may kindly come to the advertisement, the notification published by them. Annexure 2, running page 65. Your lordship got it? Annexure 2, running page 65. Your lordship may kindly mark this notice itself. Pursuant to, with the lordship's permission, I am reading. Pursuant to advertisement number so and so, this is a composite advertisement for 8 category of posts. It is informed to all concerned that as per clause 4 of the advertisement, preliminary examination will be held for the following posts to shortlist candidate for main written examination. And there are 4 categories of posts for which preliminary examination has been decided to be conducted. TGT Arts, TGT ODIA, TGT Science PCM, TGT Science CVZ. Next, my lord, your lords may skip over the next paragraph. Next paragraph, which is the penultimate paragraph of the very same page, your lords may kindly see. Like last recruitment of teacher, no preliminary examination will be conducted for Hindi teacher. This decision is being assailed before your lordships with a prayer for its passing.
Page number?
My lord?
65.
Page 65. Page 65, my lord.
Candidates are advised to keep touch with
My lord, may
like last recruitment teacher.
No preliminary examination will be conducted for Hindi teacher. So this decision taken by the authority is under charge.
Conducted for Hindi teacher, Sanskrit teacher, Telugu teacher and Urdu teacher and physically education system.
They will directly appear in the main written examination. Your Lordship, kindly see the first paragraph.
One second. Slowly, we'll go by one by one.
Sorry.
One by one, huh?
My Lord, I would request
This is dated
12/2/2025.
Yes, madam.
Did you object to this?
Madam, but then let him answer. Madam, let him answer.
No.
Madam,
The question was put to you. The question was just please. Don't
Clear to you.
comment in that manner.
Question was subtle.
Comment in that manner.
Both you should smile and then I will hear the matter.
My Lord, may kindly see.
All these things pass orders on that intervening application and modification of the order. Both first you should smile at each other.
My Lord, may kindly see.
Yes.
My Lord, your Lordship, in course of the...
One second. See, there are Saptaswaras. Do you know? Sa, Ri, Ga, Ma, Pa, Da, Nis. 7 swaras.
Yes.
Sa is Sajja, Ri is Rishabha, Ga is Gandharva, Ma is Madhyama, Pa is Panchama, Da is Drashtara, Ni is Nishada. These are 7 swaras. Our Vedas say that chanting of Vedic mantra should be in Panchama. Then only the God will be very, very pleased. The nightingale sings in Panchama. Therefore, if somebody sings very beautifully, we compare them to nightingale. Sarojini Naidu was a nightingale of India. Is it that? And Lata Mangeshkar, Noor Jahan. These are all nightingales because their voice is very pleasant to the listener. Yes. Therefore, in old Padivakta Shastra, Padivakta means advocacy. The Padivakta used to argue in a pleasant voice, in a pleasant demeanor, wearing the ornament of smile on his lips. There is such a shloka in Rigveda. Therefore, let us follow that.
Yes.
Is it not?
Yeah. My Lord, I would request your Lordships kindly come to the Annexer 2 on page 65 once again. Your Lordship have just...
I have said, I have read that which you have read.
Yes. Your Lordship
says there will not be preliminary examination, which you say that power is not with them.
My Lord, your Lordship kindly see the first paragraph of the very same page itself. Pursuant to advertisement number so-and-so, this is the one advertisement in respect of 8 posts.
Preliminary examination will be conducted.
In respect of these things. Four category of posts. Now, here, my Lord, our case is, it's a violation of Article 14 and 16 again.
I'll come to that. That's your contention. When you came to know of this?
My Lord, we came to know after this notice was published.
This notice was published?
Yes.
Before you took the exam?
No, yes, ma'am.
But did you point out?
Yes, your Lordship. My Lord, my humble, the reply to your Lordship's query is, my Lord, there is a condition fixed when can a preliminary examination be held.
Correct.
If the valid applications received by the commission is 5 times the total number of advertised vacancy, then only it will be held. So, in order to go for preliminary examination, the condition to be satisfied is
more than 5.
So that information
did not have.
We do not have, and that is exclusively within the domain of the commission who conducted it. Now you are not.
1 second.
Yes,
you are wrong. You are wrong because
my Lord.
Kindly see the notice.
Yes,
it specifically says
yes.
Will not be conducted at all.
Yes.
But still you participated in the inquiry.
My Lord, may kindly see. We have, my Lord, that because the clause 4 says when it will be the total number of valid applications are more which are received is more than 5 times, then only they will do. So if it will be less than that, we cannot insist upon preliminary examination.
No, it is not like that. Kindly see the text.
My lord, may kindly see.
Regardless of the number, no examination will be.
No.
See that.
No, that is
like
not the
last recruitment.
Yes, last recruitment they say. I'll explain that. My lord, they will say in which last recruitment they are referring to, and what was the condition which they are saying that is akin to the present situation for which they have adopted the same parameter here. We have clearly explained in our petition reply that the last recruitment they are referring to is not a recruitment relating to LTR and is a recruitment of regular recruitment where the total number of candidates received in response to the total number of vacancy is much less, 5 times the total number of advertised vacancy.
Question is not that. Kindly see that. Kindly see that. See, the first part, there are 2 parts in that notice dated 12/2/2020.
Yes.
Do you agree? There are 2 parts.
Yes.
Kindly look into it, then agree.
Yes.
It is annexed 2.
Yes.
First part says, the preliminary examination will be held as per class 4.
Yes.
Class 4 says, if it is more than 5 times the vacancy,
yes,
then it has to be held.
Yes.
Then the second part says,
yes,
we will not hold for these posts.
Yes.
Whether that is right or wrong is another thing.
Yes.
But they have made it clear to everybody,
yes,
that we will not be holding the preliminary exam.
Yes. Your Lords may kindly come to Annexure 4 on page 77.
Page 77.
Yes. And your Lordship have seen the date, that is date of notice is 12/2/2025. 12/2/2025. Your Lordship may kindly see Annexure 4. What is its date? Date is 5/3/2025.
Which is page number?
Page number 77. Here the petitioner himself was the applicant in RTI.
1 second. 77.
Yes. Here the petitioner himself had applied for the information under RTI as to how many number of valid applications were received by you, so that you have decided not to hold the examination. To that reply, they say number of applications received for all the post advertised on LTR category will be supplied after completion of the recruitment process. So that is why we were bound to appear at the main written examination conducted by them on 15/5/2025, much after this. Your Lords may kindly mark the dates. Main written examination was ultimately held on 15/5/2025. This notification under Annexure 2 is dated 12/2/2025. We applied under RTI, to which they responded on 5/3/2025 saying,
what you had a sort for?
Madam,
how many percent?
How many valid applications were received?
How that will be relevant for the second part when they are saying we will not hold preliminary examination at all?
Because now the counter they say we have received the less than 5 times the vacancies in all these categories of post, which includes, your Lords may kindly see, Sanskrit teacher, Telugu teacher, Urdu teacher, physical education teacher, which has been clubbed together with Hindi teacher. In their counter affidavit they say. So it is not a case that they are not holding this because of this. My lord, this is a case where even if they were mandated under the conditions fixed under the advertisement to hold the written preliminary examination for Hindi teacher post, for the reasons which is beyond normal comprehension, they have abandoned it. That is what is clearly evident from all these documents. And when this happened, my lord, your Lords may kindly see the predicament of the candidate. My lord, we were there as a candidates. We were bound by the terms and conditions fixed in the advertisement. If, my lord, again I am going to the original condition, whether such a power is available to them, that your Lordship will certainly decide ultimately whether that was available in terms of the advertisement, which they can do. Next question is, we are also challenging this before the result of the written examination is published. So question of waiver and acquiescence will not be affected because question of becoming unsuccessful has not yet been tagged to us because the result has not yet been published. We have only applied for it. And that too, in a recruitment which is again suffering from the vices of not following the mandate and in the method through which the recruitment was supposed to be made. Because the recruitment...
This is one lacuna. The other ground is what?
Other is the examination of written examination was required to be conducted in bilingual mode, which they have conducted only in one.
Very bad.
Again, your lords may kindly come to page 25.
Right.
Even this we came to know only after appearing at the examination.
Who appears for the examination board? You appear.
Yeah. I have already filed a counter also, madam. I will answer, madam.
The second contention is that the examination ought to have been held in bilingual mode, namely in English and in Hindi. Or other language also.
No.
In English and Hindi.
English and two languages.
In the case of petitioners.
In the case of in the
category of
pedagogy and evaluation. Pedagogy and evaluation.
Evaluation, that is relating to 20 marks.
In relation to
pedagogy and evaluation.
Pedagogy and evaluation.
Which is the part of a composite the examination paper comprising of 150 marks.
Which is 20 marks components of 150 marks in all.
Yes.
And that petition having been issued, the recruitment process is initiated. Where is that which says it will be held in bilingual?
My lord, may kindly come to Annexure 5, running page 78. The very next page, your lords may kindly see.
Page 78?
Yes. That is what the commission himself by way of notice admits.
No, that is it, page 25.
That is at page 25.
25.
Yes, page 25, vis-a-vis.
Page 25. That is the part of the advertisement.
This is part of the advertisement, more particularly at page number 25.
Yes. Correct. Clause 4B, clause 4, subclause B. Details of the main written examination is shown below. Clause 4 starts from the previous page. It is in continuation thereof. Next page, details of the main written examination under which, as against the Hindi teacher post, it has been mentioned as 150, and the last column says English and Hindi, Roman script and Devanagari script. And the top of the marginal heading is language / medium.
That is relating to 20 marks.
It's only 20, consists of 20 marks.
Yeah, there is no mention in the advertisement that it is 20.
It is in the syllabus.
Anyway, at page 78, which you are now reading,
yes,
it is mentioned that it is for 20 marks in 16 minutes of time.
But in a common paper, in a common examination, comprises of 150. That is what they admit. That is their own admission at first paragraph itself.
Correct.
Yes. Now, my lord, in the present case, the petitioner called in question both this annexure 2, the decision whereby they have decided to cancel the preliminary examination, and the second to hold this the main written examination again selectively for few people. My lord, yes,
selectively
for few people who opts for it. Annexure 5 itself says at running page 78. Second paragraph. Your lordship have read the first paragraph, the last 3 lines. Second paragraph. A few students have claimed that this has adversely affected their performance. After looking into all these aspects, the commission has decided to give an option to such students who appeared the Hindi teacher main examination on 15/5/2025. They may indicate whether to evaluate their present answer sheet or to appear a fresh examination for pedagogy and evaluation, 20 questions only if they so desire. So this is an option which is being given to the candidate who will opt for it instead of holding the examination once again after admitting that they have done something wrong in the process of examination. So this benefit is being offered to those people who will now opt for, and there will be two questions through which the examination will be conducted and merit will be adjudged, which is against Article 14, because merit cannot be adjudged in two different sets of questions. It has to be identical. It has to be single.
When the counsel for the petitioner submits that in terms of notice dated 17/5/2025 at annexure 5, an option was given to a section of candidates to appear afresh in the examination for pedagogy and evaluation. And this vitiates the common platform on the basis of which the candidature of participants ought to have been assessed, judged. Okay. So first contention is ratio violation. Yes, where ratio exceeded 5 times, they ought to have held a preliminary examination, which they have not done. Number one. Number two, they should have held it on a bilingual mode, which they have not. Number three, having realized their mistake, they permitted those people either to indicate their consent for valuation of the scripts which have already written, or to go for the fresh valuation. But either way, it is vitiated, is your contention. Number three.
By holding a fresh examination for those who will opt for.
They held the examination also?
No.
They have not held.
Because of the interim protection granted by this Hon'Ble Court.
No.
So my lord, what they propose to do is, by virtue of that the document under Annexure 5 notice is that whoever will now opt for,
they will hold separate examination.
Separate examination.
That will not be permissible. And it appears that way.
And so that is for all.
No.
Whoever opt.
No.
Whoever opt.
No, if you opt for that,
yes.
Now fresh questions will
be. Choice is given to them.
The common practice.
Yes. Choice is given to them.
Yeah.
Who has opted?
Why choice?
Because they committed a mistake.
Then
they committed a mistake. They committed a mistake, and since some candidates have raised their objection, therefore this notice was issued on 17/5/2025. Who opt for examination in bilingual subject, my lord, then they will be permitted.
In which language you have written?
Because the question was in one language, there was
Hindi. You have written in Hindi only.
Yes.
But now suppose if an option is given to you, will you go for English?
My lord.
No, I want to know. Just want to know.
My lord, in that event,
because the same question you will be writing in Hindi, in English.
Yes. My lord, may kindly see.
May I permitted to interpret just clarification, madam. Questions are actually the multiple choice questions. So they are nothing to write, my lord. They have to put tick marks.
Just tick marking.
Tick marking.
They are not descriptive answers at all.
The plan of the question is indicated in the page number 25. 150 mark MCQ type of questions. Multiple.
So not descriptive at all. Just tick marking. That ought to have been in English also, is their version.
Yes. So after him, I am permitted to clarify.
My lord, with regard to whether he will appear, the candidates will appear in English or not, that I have to take instruction, because that question never came to my mind. Since it fails from your lordship's mind.
No, even other way. It's a MCQ.
It's an MCQ. My lord, now the question is, let us suppose we will opt for it. Well, there are two contingencies. Either we will opt for
opting, we will exclude. Now, I will tell you, this option question will not arise. I'm just thinking aloud.
Yes, your lordship.
Whatever examinations have been written now.
Yes.
That assessment.
Now, my lord, our prayer before your lordship is, if at all you are going to hold another examination, then kindly hold this examination for all, not selectively to few who are now opting, because there will not be a common platform for adjustment of merit.
Because questions will differ. One set there will be one.
Yes.
There will be different.
And the standard will be different. Maybe it is in MCQ form. Maybe it is in Hindi the language or English language. Maybe somebody will appear in English and some other will appear in Hindi. That's a different issue which will come. If at all,
how you are aggrieved by
our main contention is now, my lord, not holding the preliminary examination amounts to changing the rule of the game before the game is played. That is what our contention, and we are.
One second.
Yes.
Let us see his answer to your first question.
Yes.
Yes. Will you permit me to put question?
Yes, your lordship. Yes.
Yes, sir. He has permitted now me. So therefore,
no, it is your lordship. It is your lordship's authority.
What is your answer?
My lord, first of all, my lord, I will take your lordship to page number 24 once again. That condition stipulating that plan of examination with preliminary examination. May be permitted to read once again.
24.
No, page no 24. Stage 1, preliminary examination. Objective type, MCQ, one paper, mass allotted 100. It is qualifying in nature, full stop. Preliminary examination will be conducted for such post where number of valid applications are more than 5 times of the advertised vacancies, full stop. Based on marks obtained in preliminary examination, approximately 5 times the number of candidates will be shortlisted post-wise, category-wise for appearing in the main written examination. So, my lord, the basis of the preparation of the select list is dependent upon the main examination, but it is for the purpose of the shortlisting. The preliminary examination is there. The preliminary examination is there. So, my lord, lordship may come to my counter.
No,
the figure, my lord, what they have proposed, they have placed. Now, my lord, may I be permitted to place the figures? So, may I take your lordship to
my counter?
Yes, ma'am, my counter. I may take straight away because all the things
are not available yet. Yes. It's a hard copy.
Yes, ma'am, it has been filed since long and they have already filed a rejoinder also.
Counter, where is my counter? Hard copy not available. Now, go to our
may I supply a copy, my lord?
You have one? Yes. Do you have extra copy? Yes. Yes. Thank you. Give that.
Sorry, my lord, because I have put some marks there. May I?
No problem.
May I be permitted to?
He wants to get it substitutes.
So that it will be easier for me to.
Correct. Yeah.
So, my lord, may I take your lordship to page number 4, madam?
Page 4.
Because I am answering to the first question. First question, yes, ma'am. Page number 4.
Page number 4.
My lord, para number 10. Because what it has already been placed before lordship, my lord, I am just clipping it, ma'am. That in response to the advertisement dated 22/10/2024, the number of valid applications for each post are like this, my lord. My lord, we are concerned with the Hindi teacher, ma'am. Lordship may come to page number 5. Hindi teacher, it is 4485. 4485, madam. 4,485.
So many people had applied.
These are the valid applications.
The vacancy position was
711.
So it is much more than 5 times.
That is why, my lord, actually I placed the full paragraph of that preliminary examination. Now, my lord, I may be permitted to place. Lordship may come to page number 6 at distance. Page number 6, my lord.
Yeah.
So far, para number 13, because your lordship found that in annexure 2, there are 4 categories of the post for which, my lord, there was no preliminary examination, including Hindi. 5 times over. My lord, here it is indicated, my lord, that the name of the post.
Urdu, Telugu, you did not hold preliminary examination. We can understand because number of applicants is very frugal.
Yes.
Then Sanskrit is 4969.
Yes, ma'am.
Hindi is 4493.
Now, my lord, para number 14. Up to that stage, my lord, we have clarified that regarding that annexure 2. Now, para number 14. With respect to Hindi teacher, my lord, UR category, SCBC category, SC category, ST category. Similarly, my lord, the next page Sanskrit, thereafter, my lord, physical education. My lord, the vacancy position as against 356, it is 977 so for UR category. So for SCBC, it is more than 5 times. So for SC and ST, less than 5 times. So once the motto of the preliminary examination, my lord, 1 second, I am taking your lordship to that particular page number 25.
25 of the petition.
Page number, sorry, my page number 24.
24. It is qualifying nature.
Yes, madam. Preliminary examination will be conducted for such post where number of valid applications are more than 5 times the advertised vacancies.
1 second, slowly.
Yes.
Preliminary examinations will only be conducted.
Yes.
For such posts where number of valid applications are more than 5 times the advertised vacancies. Therefore, the posts and the number of persons who have applied. These are the basis.
Now, my lord, based on marks obtained in preliminary examination, approximately 5 times the number of the candidate will be shortlisted post-wise and category wise.
This is after conducting the preliminary examination.
My lord, my submission, my lord. Our aim is to conduct the examination to get shortlist of candidates to the tune of 5 times. When we do not have the members to the tune of 5 times, then, my lord, in that
Why
case,
do you say like that? Arithmetically, you have more than that. You had totally vacancies were 711.
My lord,
whereas the total number of persons who applied was 4,493.
My lord, that is what we are submitting. Once we are by passing this hurdle of this preliminary examination, at the time of recommending the name to the main examination, my lord, at that particular point of time, we have to recommend the name of the 5 times of the categories of the post. Not only the type of the post, my lord, post type, but category wise also. Now, category wise, my lord, you are SCBC, SC and ST. Only in respect of SCBC, it is more than 5 times. Lordship may come to page no 6.
No, that comes after holding the preliminary examination.
My lord, that after preliminary examination, my lord, when we have the number of applications with us, which is less than 5 times in respect of all the 3 categories, excluding SCBC, then, my lord, how we can, what is the, there is no reason for conducting the shortlisting, my lord. The reason for conducting the shortlisting is always, my lord, as per the decision of the Supreme Court, my lord, it is always when the number is large and
when to reduce the number of competitors.
But here, my lord, the question of reducing the number, it is already reduced. They are actually calculating, misinterpreting that by reading only one para, my lord. But when our duty is not only to conduct the examination as per the first line, but also to prepare the list according to the second line. So the first line and the second line of the preliminary examination schedule, my lord, that is to be read harmoniously, my lord. It will be conjointly, my lord. So since the motto is to prepare a list category wise, and as I have already placed it before lordship in para number 14, the number of the candidates who are available, my lord, in respect of UR category, SC category and ST category, it is less than 5 times. My lord, at this juncture also, my lord, may I take your lordship to the next page?
You mean to say no purpose will be served at all?
No, that is the purpose. Because the very purpose of shortlisting the candidates through preliminary examination, which is a common examination, my lord, there was no difficulty for the Staff Selection Commission to conduct the examination for all the 8 papers because that is common. But when our purpose is not going to be solved, my lord, by keeping an examination of the preliminary nature with respect to these 5 posts, that is why, my lord, we did not. And my lord, in respect to the Sanskrit category also, your lordship may peruse, excluding the category of the SCBC, in all the three posts, my lord, all the three categories, the portions are less than 5 times. And that examination has already been held. And similarly, my lord, in SCBC category, physical education teacher.
Yes.
So, taking into consideration the total number of the vacancies, yes, admittedly, my lord, the valid number of applications are more than 5 times. But with respect to the category wise, when we are supposed to prepare it,
read it tomorrow.
Yes, yes.
My lord, have you got the point? What he's saying?
Yes. Can I?
No purpose would be.
Yes. Can I?
By holding the.
Can I only submit one line?
Yes.
My lord, may kindly.
You can make it 2 lines tomorrow.
As your lordship.
My lord, item number 55, my
My
lord.
lord,
55.
My lord, if it's covered by Ashok Mahapatra, my lord.
55. Is it you, Mr. G?
My lord, will you take this matter at 2 p.m. At 2 p.m.
So that PM you want? No.
My lord, similar order already.
It will not put it as 2 p.m. It will come in the list. When it reaches, if it reaches before 2, then you can mention. If it reaches after 2, the question will not arise.
My lord, similar. Item number 15, my lord. Your last part.
But tomorrow we want to do something because we cannot this side or that side.
Yes,
we will make something.
My lord.
Similar matter has been disposed of by my lords, keeping in view the
Identical. Identical or you have changed the dates, etc. Nothing is to be.
My lord, dates has not been mentioned. Only the case number, OA and the SLP number.
Same.
That will be the same intact.
So identical order. No change at all.
No.
Only case
55.
All the methods.
Item 52, my lord.
1 second. 55. How many methods are there?
11. Around 10 to 11 matters.
Same all these.
Item 52, my lord, I will file objection to the intervention petition. 1 week time maybe.
The only difficulty, your lordship, they are constructing the work and virtue of the interim order that has been passed by your lordship. And I am insisting on the early listing of this matter. That is what I am still insisting. Because it has already been
1 week after any date.
We'll have it on 3/11.
Lordship. Interim order to continue.
But in our case,
Your lordship, I'm for 1 and 2.
In which system?
Your lordship, for item 52.
52.
Yes, your lordship. We pray for 2 weeks time to file the counter along with the wakalatnama.
We are running now? 3/11. It is more than 2 weeks.
Yes.
Interim
order.
Obliged.
My lord, item 55, my lord. What matter also?
But 55 that we have passed this order. Similar matters order has been passed. We have supplied because no. It is case is given.
Yes. Disposed of already. Yes. But wherever interim order is there, in all cases, interim order to proceed. Right?